And the inquiry is resumed. Thank you. Just a few bits to run through before we move on to closing submissions. The first is that on a Tuesday the fire alarm's tested. I've not heard it tested yet, so if it goes off... Oh, it has been. Thank you. So if the fire alarm goes off, we need to leave. Okay. Is everyone able to leave by themselves? Mr. Templin.
Help, madam, because I heard the alarm being tested earlier this morning.
Right. Thank you. So, does anyone need help to leave if the alarm goes off? No? Thank you. And if you could just turn off mobile phones or set any audible notifications, put them on silent, please. So the other matters that I just want to touch on mainly relate to conditions and documents that have been submitted. The first one is Mr. Tamplin, on behalf of Poets, submitted the wording for an additional condition, which we discussed in the session on Friday, in relation to the establishment of a joint liaison committee. But the wording has been updated, Mr. Templin, and I haven't had a chance to do a compare, so I don't know what the difference is.
Thank you, madam. Yes, I'm sorry that it was late, the submission, but I had not realised that there were a couple of omissions and some corrections, and I've put that in yesterday evening. I don't think they're very significant, but I just leave it with you and anybody that wishes to say anything beforehand.
So, could you just tell me what the differences between the two documents are? Were they just sort of typos, or is there anything significant?
Thank you. I'm searching for my copy of it, which I'm afraid I can't put in because it's been scribbled on.
No, that's fine. We've got the other one, but I've only read the first.
It's basically some wording such as agreeing the terms and reference and the remit of the committee at its first meeting, and saying explicitly that reports to the committee should be from the applicant, because that's the purpose of the condition, that the participant councils, that's district and parish councils, and the residents thereof should have the opportunity to consider matters that are before the committee and see them publicly, so they're made publicly available. I think those are the two main changes that I made.
Thank you, Mr. Templin. Mr. Flanagan, does the council have any comment on it beyond what we heard on Friday?
We do, thank you. As I understand, I appreciate I wasn't here leading on Friday, but I've spoken to those around. As I understand, on Friday we said we'd take it away and have a think about it and then give you our views. So if I could give you my views, well, our views now. In principle, we say that this condition is not necessary and does not meet the tests for a condition. And briefly, there are 4 short points as to why we say that. Firstly, we say it's unnecessary to create a liaison committee when the local planning authority, OCC as local planning authority, already exercises the role of monitoring conditions, also exercises functions in relation to condition discharge applications, which creates scope for input from interested parties as well. So it's duplicative of the LPA's existing statutory roles. Secondly, we say there's already avenues to raise concerns if people are concerned about construction. There's the obvious avenue of speaking to the LPA, whose, as I say, role this overlaps with. And there's also other democratic avenues speaking to district councillors or county councillors? Thirdly...
Sorry, can you...
Sorry.
Okay.
Yes, so thirdly, we say that this project is not so extraordinary or unique in its scale or effects that it is necessary to create separate formal structures in parallel to the existing ones which the LPA has, which will, with all the extra workload and administration taking people away from their other tasks, as it will result in. And fourthly and finally, as a connected point really, that OCC as applicant is not a private developer, it's already a public body. It's already subject to public scrutiny accordingly. It's just another reason why we say it's unnecessary to create such a committee. So those are the, in principle, reasons why we say it's not necessary, doesn't meet the conditions, the tests for conditions. I've got a few then short points. If you were to impose such a condition on the detail of it, without prejudice to sort of primary position, as to what such a liaison committee condition should say.
So before you go on to that, is it something that would be picked up? I think Mr. Champlin's position is more about the construction period, is that right? Or is it the details? I can't...
Yes, madam, it's principally the construction period, which is, as I said on Friday, going to be over 2 years. I think that's been repeated several times in the inquiry. And its scale and extent is such that it puts it on a par, indeed much bigger than many mineral schemes, which the County Council are very familiar with, where there are already such liaison committees in existence. There's indeed one at Appleford in relation, I believe, to the Hanson site or the FCC site.
Thank you. And in terms of this committee that you're proposing, obviously this is a linear scheme, and as we've heard throughout the inquiry, there's a number of local planning authorities, parish councils impacted by it. How do you see that one representative of the parish, all the parish councils? I'm just wondering if we're looking at the works in Culham, to what extent Didcot Town Council, it's relevant for Didcot Town Council to be involved in that.
You raise an interesting point, madam, and in fact, in terms of the, if you like, relationship with Culham, yes, obviously there's Didcot, which is included in the list I have, Didcot Town Council, but in fact, in relation to Culham, that immediately adjoins Abingdon, and I haven't included that in the list. But I would certainly have no objection if that council was also included, because of arguments elsewhere on the effect of the scheme, including its construction. And
sorry, do continue.
Sorry, and this is really to go back to the first question you asked me. I'm sorry, I should have added in my answer that yes, it's principally the construction period, but it is also, I had envisaged it being beyond that first period to the first 5 years of operation, because a lot of the planning conditions that have been put forward, dealing with, for example, planting and so on, require oversight for 5 years or more. and therefore it's really a sort of oversight of the implementation of the scheme and ensuring that the conditions are observed in a way that is not going to be detrimental to local people.
Thank you. And the point I was trying to make, which I perhaps haven't done very well, is if it's happening in one parish council area and another parish council separated from it by some distance, why should they be involved in that matter?
The only parish council that is separated from the actual site of the scheme, and I use the word precisely, site of the scheme, on my list is in fact going to be Newnham Courtney Parish Council, but I think that the inclusion there would really be in relation to what I've just said about Abingdon. That's a matter of judgment, I think, for you, the Secretary of State, to make.
Thank you. Right, so Mr. Flanagan, I don't know if you want to say anything in response to Mr. Tamplin's point, and also whether it's something that could be picked up as part of the construction environment management plan.
Yes, in response, I won't repeat what I've already said, obviously.
No.
In respect to the comparison with minerals permissions, we say it's not comparable. The minerals permission, by its nature, is often in the same place for years. It's not linear construction. Years, potentially decades. The impacts are quite different. So you might, as I understand, they do exist, liaison committees in respect of some private minerals developers, but what we've got here is a linear construction scheme, 2 years construction for the whole project, and obviously, Madam, as you indicated, it proceeds upwards, so it won't be the case that everyone's subject to that for the entire period. So that's the comparison. In terms of a few points of detail which you raised, the reworded condition does stray into operation. So it's worded now to monitor the implementation and initial operation. So obviously we say none of this is necessary, but operation is particularly should out of the purview of this. What's going on there is essentially duplicating the highway authority's powers and duties in respect of, managing the highway network, which is not the role of a planning condition. In terms of the mechanics of the condition, it provides that the various parish councils sort of have a seat on it, as are the 2 districts in the county, but it's to be a majority voting mechanism, such that the parish councils always have essentially a majority, ability to overrule the district and county councils, and will be able to require, therefore, the production of reports from the applicant on whatever they wish, whenever they wish, according to this condition, which is an extremely onerous requirement. So we say that any voting mechanism needs to recognise the nature of the county and the district, giving them equal weight at least, and it should not enable the parish councils to, as it does at the moment, require the production of reports from the applicant. In terms of timing, it's suggested that the meetings be monthly. We say that is, again, overly onerous. We think at most every 6 months, if there were to be some such condition, would be more than adequate. Would provide for at least four meetings during the 2 years or so construction programme. But monthly, it's a significant time investment by the relevant officers and people working on the project. Just check if there's anything else. There was a point of detail. Western Valley Parish Council are not on the list of invited participant parish councils, and that's the new one being created at the south of the area. They ought to be on the list if there were to be such a condition. The point about the construction management plan, if I just turn my back briefly. So Madam, I think entirely right. The construction management plan would allow for some existing liaison with the districts and the contractor. That being the nature really of a construction management plan. I don't have there is an outline construction management plan within the documents, which I don't have to cite. Perhaps, I mean, I'm certainly happy to have a quick look at it over lunch and see if there's any specific provision which would assist on this front. But I suppose it does fall into the category of an existing mechanism which, again, overlaps with what's being proposed.
Thank you. I can see that there's nobody from the local planning authority here.
They're on Teams.
Oh, they're on Teams, right, excellent. So my question to them, I'm not sure who it might be, if it's, let me just have mine on. I'm sorry, Joe. Yes, I'm not sure how I connect with him on my version. If I can put can Mr. Perriam hear me? No?
Yes, Madam. Yes.
Excellent. I can do it without seeing you. When details pursuant to outline application, it's not an outline application actually, when details pursuant to conditions are submitted, is it general practice to consult those that you consider to be impacted by it?
Yes.
It is. Thank you.
Yeah.
That's all I wanted to check, Mr. Perriam. Thank you.
Okay, thank you.
So, Mr. Tamplin, have you got anything further you want to add?
Very little, Madam. On one detailed point, I wasn't aware that the actual site of the road covered land in the Western Parish Council area. If that's the case, then of course they should be included. If not, they fall into the same category as Newnham Courtney and Abington. That's the small point. I only wanted to say, Madam, that the County Council has answered what they've said. On the one hand, that the conditions is going to create extra load for the LPA and the authority. Well, I'm afraid that is for the County Council to sort out between themselves, because they have created the scheme itself and they have created the workload for somebody, whether it is parish councillors, district councillors, county councillors, and that is not an answer. The other point on which they contradict themselves is that they say the County Council is already a public body and has oversight of matters like submitting of schemes, and I accept what Mr. Perriam has just said, that they do consider these things. But I think I would ask you, Madam, to respect what the parish councils in particular have said, that the LPA and the county council as a whole are simply not trusted by people who have had experience of dealings. Now that's a fault of the system, and it's not something really that either you or the Secretary of State can deal with, but I think it's an important point to make.
Can I just check I've got that last point right, that the parish councils don't trust the county council? Is that what you're saying?
I'm saying, sorry Madam, I'm saying that the residents of those areas do not trust the county council to, if you like, oversight, to have oversight its own scheme.
Madam, could I make a comment?
If you can just wait a moment. Sorry, yes.
Sorry, can I speak now, yes?
Yes, sorry.
Yes. Sorry, Madam, I just wanted to make the point that Appleford, along with Sutton Courtenay and one of my colleagues from the Liaison Committee on the Minerals aspect is here today. And we find such a committee to be extremely useful and constructive for bringing matters more effectively to the attention of all those involved. And it works extremely well. It's also a direct input from the community, which enables the community to bring issues before almost the decision makers involved in the matter. And the other point is that some of the issues in the construction management plan are really between the applicant and the contractor, whereas I think this is slightly wider with the impact on the local community, where such a committee would enable a direct input to bring concerns forward.
Thank you. Mr. Flanagan.
Thank you. I've just got one specific point. It's only on the construction management plan point. So I've had a look. What we've got at the moment is an outline environmental management plan, and the reference for that is CDA 0.17.7. And then importantly, we've got condition 3, draft condition 3, which requires that prior to commencement of each part of the development, a construction environmental management plan shall be submitted to and approved in writing. And that has to include, I'll just pick up the relevant points, as a minimum, it has to include, this is the first bullet point, condition 3, details of the roles and responsibilities of those carrying out the construction and details of the communication strategy with local residents, landowners, community groups, businesses and others that may be affected during the construction process. And bullet point 2, details of construction phasing. And bullet point 3, details of how complaints can be made and how they will be managed. And then there's a fairly extensive list of further matters to be included. So I'm grateful for you raising it, Madam. It clearly does overlap with the current provision that the CEMP would have to make and would be controllable by the local planning authority because it would be a document approved pursuant to condition.
Thank you. I just want to check, could we go to Teams again? Mr. Perriam, are you there again? No?
Yes, madam. Yes, I'm here.
Do you have any comments yourself on this?
On the condition, so the condition, other than to agree, I think I did say on Friday, really, with Mr. Tamplin, we don't disagree. It is something we do cover by condition on minerals permissions, and Mr. Bryn's just referenced a very close example at Sutton Court in Appleford that has been running for a good number of years. As to the detail of the wording, I also accept some of the points Mr. Flanagan's made now, but I think maybe, Madam, that's something you'll just have to consider. I don't think I want to say anything more specific about it. Thank you.
Thank you. Is there anything additional or different that anyone needs to say on this? No? Okay. So Mr. Tamplin's wording will be added as an inquiry document, so it will go to the Secretary of State. Thank you. So the second point on conditions is Mr. Perriam forwarded the Council's comments that he read out during the conditions session on Friday. They relate to conditions 12, 13, 15, 29 and 30. I wouldn't anticipate there to be any comments on those. Again, they'll be added to the website. He actually read through them at the time, but because of the length of it, I asked for the written extract. And the other documentation that I've received is in terms of the Bridge Farm area, the decisions and the restoration plans in relation to that. There's quite a few documents. I'm just going to look at them and put what I think is most relevant on the website, but I don't know if there's any comment from the Council first.
I confess I haven't seen them. If they're simply the permissions and the decision notice is in relation to Bridge Farm Quarry, then we've certainly got note. That sounds useful to us.
There's no comment at all, but whether we need all of those documents, I'm not persuaded that we do, but I haven't had a chance to look at them all.
Could I just say, when you are looking at them, on our note on Bridge Farm Quarry, which is an inquiry document, we included an extract which we understood was the most up-to-date restoration plan, and no doubt Mr. Perriam's documents might relate to or duplicate that plan, so you've already got one of them already, I think.
Well, I'm happy to, they have been forwarded, I anticipate, to the Council. I think they came in lunchtime yesterday, or I got them lunchtime yesterday. If you've got a view as to whether they're all needed or fewer, I'm happy to receive that, because we're not formally closing the planning inquiry for until we close the orders inquiry. But I think that's just a detail, and I think they're uncontroversial. Have the parish councils got any comments on them? No? Thank you. The next point, I think I know the answer. The programme officer has a copy of a draft Section 106 agreement, but my understanding from Friday, it's Section 106 agreement. Sorry, I'm not sure if it's an agreement or an undertaking, but it's with the districts, and that you're not relying on them was what I understood on Friday, so they don't need to be admitted to the inquiry. Is that correct?
It's certainly the case that we're not asking you to place any reliance on it.
Right.
Given that it's something that we reference in our documentation, and we thought it might be useful for it to be an inquiry document.
Okay, we will add them to the inquiry website. So I've not seen them, but I'll have a look at them maybe at lunchtime. Okay, has anyone else got anything on documents? No? Then the final point, I think, Mr. Flanagan, you sent a message last week, which I'm afraid I somehow didn't come to my attention until quite late yesterday, about the orders inquiry. and you've suggested the procedural approach to hearing the evidence, and I'm quite happy with what you've set out there. It's not really the order in which I'd usually hear it, but I don't think it makes a difference given the time that we've spent on planning here. The running order, the programme will be updated today to set out the order of the witnesses, but everybody's aware of when they're due to appear. And Friday's reserved for modifications, and I've received that. In terms of the matters that the Secretary of State will want to be informed on, obviously the issue about the extent, having a clear idea of how you're going to use the land and conformity with the planning framework, we've heard the evidence on that, and I wouldn't expect you to spend very long on that unless it's raised by a party in their objection. And the rest of it, I would say that I would probably slightly reframe the issues from the previous inspector, but relying largely on paragraph 106 of the compulsory purchase order guidance, and that sets out quite clearly the matters that the Secretary of State is likely to have regard to. I don't think it takes you to anything new, but I think it's probably got slightly different emphasis, and that's how I would intend to proceed. Because this has only come to my notice quite late, I haven't really got the time to put out a note that would be meaningful to most parties on it. But if you think that's something that we should do, I'll see if I can do it at lunchtime, but it's a bit of a push.
Sorry, a note on procedure or the issues that...
And the issues that... I think the order's not that different from what's in the original note, so we probably don't need to touch on that. And I wouldn't have thought that the issues are very different, but from there...
The Secretary of... Sorry, just slightly thinking out loud, but the Secretary of State's issues, if you're referring to the three Secretary of State's issues in the call-in letter...
No, I'm not.
Oh,
Paragraph 106 of the compulsory purchase order guidance. I'm not sure if that's an inquiry document or not. So the first one is about whether the land being acquired fits with the adopted local plan for the area. That's the planning issues. The second one, which I don't think is really specified in the previous inspector's note, is the extent to which the purpose would contribute to the achievement of the promotion or improvement of economic, social or environmental well-being. Whether the purpose could be achieved by other means, potential viability and a general indication of the funding intentions. So they're all set out there, and I would need to report on those matters.
So that the issues there, under the heading of Section 226 of the Town and Country Planning Act 1990, are principally directed to planning CPOs as opposed to a Highways Act CPO. Although, I mean, I take the point that a lot of them will be
a lot of those
relevant.
will be relevant, and they're not very different. They're just specified. So, and I think they're probably covered in evidence that you've submitted.
No, understood.
Okay. Thank you. Right, the one final point, I think I've received an email regarding the orders inquiry from the parish councils, which has been forwarded to you, and I've sent a brief response on it, trying to just clarify where we are. I understand where we are with the joint parish councils, but I'm less clear on the individual ones. So if that could be responded to later today, that would be helpful.
I have responded to that
oh, you have done,
point
right.
already.
Thank you.
Probably haven't seen it so far.
No, I haven't, but thank you. Right, so that's all I've got. Is there anything else from the council? No, thank you. From the districts? No, thank you. No. In which case, Mr. Woolley, we'll hear your closing submissions.
Madam, I take it you've got the text of what I'm going to say. You have now, anyway.
I have now.
I'm afraid there won't be a hard copy for everyone, but we'll do our best. When all is said and done, the promoters and supporters of this scheme face a fundamental difficulty. On the one hand, they have to meet the requirements of central government for substantial additional housing and employment in the Southern Vale area. On the other, they have to do so and at the same time reduce carbon emissions as demanded by the recently amended NPPF and the more recently adopted development plans, and in the interests of the planet as a whole. The scheme attempts this difficult feat by the compromise of building a road. But like many such compromises, this one is deeply unsatisfactory, we say. First, it does not even try to achieve the ideal, and that is the removal of all congestion. Secondly, it offers an unnecessarily elaborate solution to a problem which we say has been exaggerated. This was done to justify the building of the road, and there is much materials to support that criticism. In the first place, the traffic congestion upon which it relies greatly is limited to peak periods. Nor did the suggestion of the congestion being considerable commend itself to Ms. Curry, whose view is that the highway network is not heavily congested. And that opinion gains further support from the history of the appeal which we looked at earlier in the inquiry in Sutton Courtenay. And I see I managed to put two spelling mistakes into Courtenay, which you will no doubt correct in due course. It's difficult or impossible to reconcile the fact that Oxfordshire County Council withdrew its objection to the proposal that was then before the Secretary of State to build over 100 dwellings on traffic grounds. It's difficult to reconcile that fact with a series of refusals of permission for single dwellings by inspectors on the grounds that this would exacerbate the congestion. It must follow that Oxfordshire County Council, on that occasion at least, accepted that the problem was less acute than is now claimed. Additionally, the photographs which we saw earlier in the inquiry and were produced show that the network is not overloaded, even at the places where the congestion is said to be greatest. And finally, there is the evidence of the gentleman who early on told us that he gave up sending his children to school by bus and now drives them by car instead. He could hardly have done so if traffic conditions were intolerable. The third defect in this argument is of the compromise solution is that it is no more than a temporary expedient, and arguably that flaw is fatal. On Oxfordshire County Council's own assessment, the scheme results in the network functioning in much the same way as it does now, 10 years after it opens. Further, the County Council appears to regard that as a satisfactory result, since they seem to have given no thought as to what to do to cater for year 11 and beyond. However, it is plain that development will continue for many years in the future if projects such as the Culham, Berrinsfield and Didcot housing schemes are carried through to completion. It cannot be that yet more road building will be seen as a solution to the problems posed by the desire for travel in the relatively near future. And here it's necessary to turn aside and consider the question of induced traffic. Incidentally, this expression seems to mean something different to each witness who covers it. And whatever induced traffic may be, it is at most, we say, of limited importance in the context of the scheme as a whole. Witnesses from Sir Ian Chapman to Mr. Disley have agreed that if a new road is built, drivers will use it. That insight is not profound, but is a common sense and everyday observation. Drivers are bound to divert onto the scheme road from time to time, and it can be expected to tempt some to abandon the bus for the car. In any case, it does not matter greatly which view on induced traffic prevails. If the County Council is right and there is no induced traffic, it will take 10 years before conditions become the same as they are today. If the opponent's witnesses turn out to be right, it will take rather less time to reach the same place. And whichever conclusion is right, the relief of whatever congestion there may be will never be more than temporary. The next defect in the scheme is that it gives insufficient incentive to drivers to get out of their cars and travel in or on different vehicles. On the contrary, we now know that there is no intention to do anything to discourage drivers of private cars from making use of the scheme road. The importance of this is shown by the latest December 2023 version of the NPPF, and by the embracing of, in quotes, decide and provide, instead of, quote, predict and provide, by OCC in 2022. The authoritative support of Sir Ian Chapman adds weight to the point, and there are two aspects to this. First, the intention to place no restraint on the use of the road is unsurprising, since the scheme was conceived in the era of predict and provide. The likely inference is that provision for cyclists and walkers was added on a date later than the adoption of the scheme. If so, it hardly qualifies as, quote, decide and provide. That suspicion is fortified by the evident deficiencies in what is provided for walkers and cyclists. They will have to make their way for 11 kilometres close to a carriageway carrying many thousands of vehicles per day. That alone is a formidable deterrent. In addition, it is clear that they will have to negotiate the carriageway at numerous T-junctions and roundabouts. It is therefore no more than conjecture whether the modal split assumed by and, quote, hoped for, unquote, by the promoter will be achieved in practice. Thus, the benefits to the health of the public for which claims are made remain wholly speculative. It is no more than a case of wait and see. And all this will impose heavy burdens on the environment and on local people, and I cover this more fully hereafter. The evidence shows that the Science Bridge and the second bridge to be built to the west of Appleford will be hugely disruptive to build, and in the case of the second of these, environmentally detrimental. That is what prompted the call for a level crossing of the private sidings there, as it did the suggested rerouting of the road further to the west to take it away from the village. Both these adjustments to the scheme are technically feasible. Next, the scheme is, on any view, ambitious, to put it no higher. No doubt, given time and prodigious expenditure of skill and money, it could be delivered. However, the promoters can point to no comparable project which they've undertaken, and the consultant in charge of the works has never overseen the building of a bridge over a 4-track electrified railway. This is no criticism of him, of course, but it fortifies the fears about the deliverability of the proposal and the value for money which it provides. Finally, to end this catalogue of defects, it is likely that an increase in traffic through Abingdon and Newnham Courtenay, which has not been assessed, will impact on the people who live there. It is clear that there is potential with the scheme for drivers who would not otherwise choose to go through these places to do so once the scheme is built. And the modelling appears to rest on the assumption that traffic on the road disappears in some explained way once it reaches the Golden Balls roundabout and at the end of the arm leading to Abingdon. The response, which is contained in Oxfordshire County Council's technical note of December 2023, states correctly that the A415 will be the route through Abingdon with or without the scheme, and the A4074 through Newnham Courtenay likewise. In addition, you have the evidence of Mr. Williams and Professor Ayres to the effect that it is self-evident that there will be substantial amounts of traffic using the A4074 between Golden Balls and Oxford and/or destinations further north and east. The modelling, however, overlooks the potential for increased volumes of traffic afforded by the construction of the road. This should have been assessed in terms of both the environmental assessment and the planning application itself. And there is at least one other reason why the modelling should be treated with circumspection. It forms the basis for the suggestion that there will be beneficial consequences, such as reductions in noise at the settlements along the route. Yet that can be true only if a substantial percentage of the traffic presently driving through these settlements is seen to be through traffic, not having a destination there. There is no evidence to show that this is so, and further, there is good reason to suppose the opposite. This is because there are alternative routes available to a driver with a destination in, say, Sutton Courtenay, to go there without taking a tortuous minor road, such as Main Road in Appleford. And that is but one example of several which might be given. All this on its own is enough to justify rejection of the proposal. There then arises the question whether its inclusion in the relevant statutory development plans is enough to save it. The answer to that, we say, is a clear negative for several reasons. First, at the risk of repetition, government policy has changed with the amendment to the NPPF already mentioned. That, I say, is a most material consideration. Second, thinking in Oxfordshire has changed. The evidence shows that the emphasis has changed over the years from the assumption that road building is the answer to all or most traffic problems to one where it is essential to look away from the private car to other means of travel. This too is a material consideration, making it right to have relatively little regard to the development plans. The third material circumstance is the belated but significant general awareness which now prevails that the problems created by climate change are acute. This too is not controversial between the parties at this inquiry. As one instance, at a late stage, Mr. Grebe drew attention to the draft South Oxfordshire District Council and Vale of the Whitehorse District Council local plan. This shows that those authorities have become so concerned about this matter that they have both declared climate emergencies. Fourth, and also non-controversial, is that there has been a change in the behaviour of the population as a whole. The most striking has been the trend to work from home, accelerated by the COVID pandemic. This has been especially marked in this part of Oxfordshire. In addition, there is the tendency for the young to abandon the car in favour of other forms of travel, and there was no challenge to the evidence on this. In urging rejection of the scheme, the objectors are not nihilistic. It may be that Oxfordshire County Council considered some alternatives to road building before they lit on the scheme as the solution. If they did, then there is a suspicion that in doing so, they were predisposed in favour of the road. This is because predict and provide was the vogue when the decision in principle was taken, and which almost certainly informed the judgment, and that although the scheme was one of the two worst environmental options, yet nevertheless it should be preferred. These material considerations which I've listed also justify a fresh round of optioneering. This will and should allow those concerned to reappraise all the alternatives to road building. And this is plainly foreshadowed in the LTCP, and it's especially necessary because of the clear opportunities afforded by the presence in the area of the Didcot to Oxford Railway, which is due for major improvements at Colham Station and to widening to 4 tracks as far south as Radley. It is not for the citizenry, for whom I act, to proffer answers to the questions which face the responsible body who's planned these things. It can do no more than put forward suggestions for those with responsibility to consider. In the meantime, relatively modest developments, such as that proposed at Sutton Courtenay, will no doubt continue to be brought forward. And this is more than a pipe dream. The examples of what has been done at Cambridge, Chippenham, and in the south of France, of which Mr. Turnbull and Mr. Tamplin spoke, show that the kind of exercise which the objectors urge upon the Secretary of State is achievable in practice. The criticism that the French example is not comparable because it concerned an urban area, while you are looking at one which is rural, is invalid. The South Vale, and in particular that part in the Vale of the White Horse, is already well on the way to becoming urban and will continue to do so for the foreseeable future. And as that process unrolls, it is accepted that integrated transport plans become progressively easier to draw up and implement. Above all, those concerned need to guard against complacency. It will not be enough, for example, to point to success in restraining traffic in Oxford City alone and to leave it there. That way lies Armageddon. In return for the questionable benefits of the HIF1 road, which on any view will be merely transitory, local people and the general public will pay an unacceptably heavy price. To this I now turn. And here the Secretary of State should have in mind at the outset that the planning authority with primary responsibility for assessing the scheme does not support it. That fact has received little attention in the course of the inquiry, but it is a highly material consideration and one which should be given considerable weight. And one can go further. As we know, the County Council, as planning authority, was initially very critical of the project for reasons which were strikingly similar to those which the objectors have put forward at this inquiry. And when the application was called in response to a request made on behalf of the Colham Centre for Fusion Energy, Oxfordshire County Council then reconsidered its position, by which time the scheme had scarcely changed. The most dramatic addition to the proposals was the provision of 50 semi-mature trees along the 11-kilometre length of the road. That appears to have been enough to persuade the authority to alter its position to a limited extent only, leaving it with the claim that its attitude is now neutral. That lack of enthusiasm is revealing and raises questions as to the arguments which led to the slight modification, as we say it is, in the Council's attitude. Parenthetically, and I might add paradoxically, you may wish to take note that the Fusion Energy Centre is to be provided with a large housing allocation next door to it on one side, and a modernised railway station on the other. And of all the organisations in the area, it is the one with possibly the least need for an 11-kilometre road by way of additional access. Returning to the question of the price to be paid in return for the construction of the road, the advocates of the project attempt to justify it by evading the inevitable. What cannot be avoided is that a new road carrying many thousands of vehicles, including heavy goods vehicles, each day, must necessarily inflict demonstrable harm on the people living along its route, on the open countryside through which it will pass, and on those objectives which the Oxford Green Belt is designed to protect. And I'll deal with these separately from now on, beginning with carbon emissions and pollution. Here, there is at least one direct conflict of evidence. On the one hand, Mr. Ung detected an increase in car use and carbon emissions since the end of the COVID pandemic lockdown, and predicted that there will not be any reversal of this trend. On the other hand, Ms. Savage detected a year-on-year decline in measured concentration. If this dispute needs to be resolved, then the safer assumption is that pollution levels are more likely to increase than reduce as time goes by, and that, if so, a cautious approach to road construction is to be preferred. What cannot be gainsaid, however, is that a new road is bound to attract large amounts of traffic with corresponding generation of pollutants. If it is still maintained that in order to justify this outcome, it is enough to point to the success of the county in reducing traffic use and congestion in Oxford city centre, then this too is dangerously complacent. The ambition should be to minimise vehicular traffic everywhere, an injunction which applies in Oxfordshire as much as anywhere else in the United Kingdom. And this is of particular concern to the parishes of Appleford and Newnham Courtenay. Appleford, first, is especially vulnerable because the road will be upwind of the village for most of the time when the prevailing winds blow, and the impact on the village cannot be underestimated or mitigated. At Newnham Courtenay, second, the traffic will travel through the centre of the village, which speaks for itself. The inquiry has had the benefit of expert evidence from the medical expert Dr. Jones on the consequences for the health of the public of the emissions from motor traffic, if that evidence was needed. As one would expect, that evidence points all one way and establishes the undoubted threats to human health from the emissions. That being so, it's hardly surprising that Ms. Savage pointed out that adopted local plan policies advocate productions of as few emissions as possible, and building the road would be a clear and obvious breach, not breach of those policies. Even if, which is of course challenged by the objectors, the traffic modelling is correct in forecasting reductions of traffic in those villages, existing conditions are such in both places that even the possibility of more pollution should deter the Secretary of State from running the risk. And Ms. Savage accepts that pollution is a cause of concern over much of Oxfordshire, and that in these circumstances, any addition would be better avoided. It would also be wrong to overlook the fact that the traffic will be going uphill as it passes Appleford northbound. This must increase the possibility that the emissions will be correspondingly greater, and the reports from Ms. Savage that there will be a compensating reduction in emissions from southbound traffic on the down gradient is no more than speculative wishful thinking. I pass on to the Green Belt. The history of the way in which the County Council as planning authority dealt with this application need not be rehearsed in detail, but is one of inexplicable inconsistency. As Mr. James and one district council officer recognised, the road would conflict with more than one of the recognised functions of the Green Belt in South Oxfordshire. This must automatically make it inappropriate without more ado, and the Secretary of State is invited to reject the artificial and largely semantic arguments which are said to point to the opposite conclusion. For instance, the argument that the road will be only a small encroachment on the Green Belt is demonstrably absurd. It is either an infringement and therefore inappropriate, or it is not. Similarly, the contention that it must be appropriate because it will be a local rather than a strategic road is no more than a verbal quibble. It is equally capable of being seen as strategic as it is a local road. Just as the two motorway service area cases cited by Mr. Grebe were held in one instance to be a strategic proposal and in the other a local one. In these circumstances, the promoter and his witnesses are consequently driven to fall back on the argument that, in quotations, very special circumstances justify the HIF1. This depends on the largely circular argument that the road is needed because of its function in releasing the sites needed for housing and employment. That might be so if, and only if, there were thought to be no alternative to HIF1 as a way of releasing those sites. However, without repeating the points which will be made clear throughout the inquiry, there is a variety of alternatives which might offer a solution to the problem, and it's not even necessary to go that far. If we have reached a position where the Secretary of State can be satisfied that it would be right to carry out a more rigorous examinations of the alternatives than was done in the County Council's optioneering exercise, then that too would remove the very special circumstances said to exist here, and Mr. Grebe appeared to agree with both those propositions. It is of interest that Oxfordshire County Council apparently received no advice from anyone other than him, which might have caused it to change its opinion on the important matter of the Green Belt. And if that is right, then the shortcomings in the reasoning identified above should persuade the Secretary of State to dismiss that reasoning. I move on to landscape. Although this is an important topic, it can be covered relatively briefly. This is because there is relatively little difference between the parties. The critical comments in Mr. James's proof on landscape are echoed, if somewhat more faintly, by the District Council witnesses. Even Miss Ash, for the County Council, expresses much the same reservations about the impact on the landscape. And this is unsurprising, since the scheme introduces large urban features into a landscape which, apart from the town of Didcot itself, is mostly open countryside. In addition to the vehicular carriageways and the cycle and footpaths themselves, there will be the large, visually intrusive and, to use a neutral word, functional viaduct and bridge structures slicing across the landscape, and which all witnesses agree can only be injurious. Once again, Mr. Grebe raises a lone voice in dissent. At paragraphs 423 and 424 of his proof, he covers the question of openness in the countryside and expresses the professional opinion that building this road preserves the openness of the Green Belt, in direct disagreement with the report of Oxfordshire County Council planning officers to their committee. And it is hard to react to that conclusion with gravity. It flies so obviously in the face of common sense and reality that it casts doubt on the weight to be given to his evidence as a whole. And lastly, noise. With the appropriate amendments, the same holds good for the noise impact as what I've said about the other consequences of the road. Miss Bowman did not address the question, but Mr. Butler fairly, albeit briefly, conceded that noise and motion go into the harmful scale when planning balance falls to be struck. And here it would be wrong to overlook the impact, which some might describe as devastating, of the construction process. Ms. Scott for the County Council does not fall into error on this score. To this must be added the undoubted harmful impact of the noise, vibration, and movement of the traffic once the road is open, which will of course be permanent. And the limitations on the reliability of the noise estimates is covered in the submissions which I made earlier in the context of traffic modelling, and they need not be repeated, valid though they remain. Finally, in conclusion, at the beginning of the inquiry, you were asked to conclude that there are 11 reasons why planning permissions for the road should be refused. If you go back over them, I invite you to come to the view that they've all been made out to your satisfaction, and that planning permission should be refused, and the people of the Science Vale should be reprieved. Thank you.
Thank you, Mr. Woolley. I understand it's Miss Lambert next.
Yes, thank you.
It's lovely, thanks.
Madam, there's just one hard copy for you. An electronic copy has been circulated both to Ms Vincent and also to the parties.
Are we able to get any more hard copies?
Madam, I just brought one hard copy with me. I understand it will be on the website and it's been circulated to the parties by email, so they should have a copy now.
Okay. Are you able to work from an electronic copy, Mr. Templin? You can. What about Mr. Woolley?
We'll do our best.
Yes. Okay. Thank you.
Thank you. These are the closing submissions on behalf of Vale of White Horse District Council. Madam, this inquiry follows a planning application made by Oxfordshire County Council for the construction of highways infrastructure, and I've summarised the components of that highways infrastructure, which I don't read out. That application was called in by the Secretary of State by virtue of a letter dated the 25th of July 2023, before a formal decision on the application was issued by the local planning authority. The location is a linear site which traverses both Vale of White Horse District Council and South Oxfordshire District Council. Most of the development that would take place within Vale of White Horse District Council is on land that is allocated, safeguarded in the adopted development plan and in the emerging local plan. As set out in its statement of case, Vale of White Horse District Council strongly supports the principle of development. The Council's decision to support this scheme has not been an ad hoc decision taken lightly, or indeed under pressure, as has been suggested by some objectors. There are a number of reasons why this contention is misplaced. Firstly, the scheme has had support for years. It is in the Council's Local Plan Part 1, dated 2016. Secondly, the Council's housing and employment strategies embedded in the Local Plan Part 1 and Local Plan Part 2 depend on and are underpinned by the Hif1 scheme. Thirdly, the Council has supported the application throughout this inquiry. It has called 2 witnesses and taken an active part. And lastly, Ms Baker told the inquiry she knows nothing at all about any pressure placed on the Vale of White Horse District Council. The Hif1 proposals run through the development plan of Vale of White Horse like the writing on a stick of rock. This development complies with local plan policies and is critical, I quote, to the delivery of the Vale of White Horse Development Plan spatial strategy for planned housing and employment supply. The adopted local plan and the emerging local plan include extensive consideration of the need for new homes in the district, which also includes meeting some of the need of the neighbouring authority, Oxford City Council. It is worth mentioning the quality of the evidence provided on behalf of Vale of White Horse. Both Emma Baker and Adrian Butler are qualified professionals. They have no ulterior motive in giving evidence to this inquiry. Their evidence was measured, impartial, and provided from a background of enormous experience. Mr. Butler's involvement in planning applications relating to sites 29, 32, 35 and 19, all housing sites, and 24, 23, 25 and 45 employment sites, and those are all set out on the Plan on Inquiry document 0302, is directly relevant. I turn then, Madam, to the main issues identified by the Secretary of State, and I start with the third matter identified by the Secretary of State, the extent to which the proposed development is consistent with the development plan for the area. Before turning to consistency with local plan policies, these submissions assess the weight to the development plan. The National Planning Policy Framework, the NPPF, is guidance. The presumption in favour of the development plan still exists. There is no such thing as an out-of-date development plan, and the starting point by virtue of Section 38(6) of the Planning and Compulsory Purchase Act is the development plan. That does not change whether or not any policies attract reduced weight, which is not accepted. As there have been allegations regarding out-of-date policies, what is required is the exercise to be undertaken under paragraph 225 NPPF, and I've set that out in full at a footnote. The proper interpretation of planning policy is ultimately a matter of law for the court. Policy statements should be interpreted objectively in accordance with the language used, read in its proper context. The policies are consistent, are recently adopted, and the support for the Hif1 scheme from the development plan for this local planning authority is overwhelming. The NPPF sets out government policy in a concise framework. Paragraph 15 tells us that the planning system should be genuinely plan-led and that up-to-date plans should provide a positive vision for the future of each area, a framework for meeting housing needs and addressing other economic, social and environmental priorities, and a platform for local people to shape their surroundings. Under the heading Plan Making, the NPPF sets out that strategic policies should set out an overall strategy for the pattern, scale and design quality of places and make sufficient provision for housing, employment, retail, leisure and other commercial development. NPPF policy provides that the delivery of sustainable development should be through the preparation and implementation of plans, and emphasises that development plans remain the starting point for decision making and in determining whether a proposal is in fact a sustainable one. In this case, the development plan was made in the context of the NPPF and had taken fully into account the objective of significantly boosting the supply of housing, the importance of affordable housing, and the various factors that inform sustainable development. It is the expression of a plan which was shaped by local people. The national context of up-to-date local plans is well known to be poor. This council benefits from a recent development plan, Part 1 setting out the spatial strategy, strategic policies and locations for housing and employment, was adopted in December 2016, and Part 2, which sets out policies and further locations for housing, adopted in October 2019. Turning to the allegations that the Vale of White Horse District Council local plan is out of date, the allegations regarding certain policies or parts of the local plan have been misplaced. Firstly, the age of Part 1. On the face of it, Part 1 appears over 5 years old. However, Part 1 was subject of a review in 2021 under Regulation 10A of the Town and Country Local Planning England Regulations 2012 as amended, as confirmed by both Emma Baker and Adrian Butler in written and oral evidence. Ms Baker told the inquiry that the review assessed whether Local Plan Part 1 remained relevant and whether it was consistent with national policy. The local plan is therefore post-NPPF. Part 1 has been reviewed within 5 years of adoption and Part 2 is less than 5 years old. The contention by some objectors that the development plan for Vale of White Horse is out of date is refuted. Furthermore, together with South Oxfordshire District Council, this council has also made considerable progress with the joint local plan, JLP, which has reached Regulation 18 stage. This is a proactive local planning authority, ensuring that its development plan is up to date in every respect. The housing requirement. There was an argument made that the housing requirement for Vale of White Horse is out of date. Ms Baker explained that this was ultimately set in Part 2 by Core Policy 4A, so there is a combined requirement of 22,760 homes for Vale of White Horse. Some of that relates to unmet need of Oxford. Whilst the housing requirement was set prior to the standard method being introduced by NPPF, the change to the standard method actually meant that the need figure was lower than that in the plan. That is unusual, but whilst the Council is monitoring against the standard method, it remains committed to supply the housing as required in the local plan. As Ms Baker told the inquiry, irrespective of monitoring, that is because of the government objective to boost the supply of housing, and by oversupplying, we are being consistent with government policy. The emerging local plan does not deallocate any of the current allocated sites, and all the current supply in parts 1 and 2 is still envisaged to come forward. The 4-year requirement. Mr Turnbull referred to a 4-year requirement, but as Ms Baker explained, this is based on a misunderstanding on housing land supply calculations for monitoring purposes. Paragraph 77 NPPF provides for a relaxed 4-year housing land supply if NPPF paragraph 226 applies. However, that does not and cannot alter the requirement in the local plan, and cannot and does not amend the overall supply to meet need that the Council has planned for. Policy CP17. Mr Turnbull had a particular issue with core policy 17 of LPP1, which was particularised during his oral evidence. He alleged it was out of date because it refers to Local Transport Plan 4, LTP4, as opposed to the more recent Local Transport Connectivity Plan, LTCP. Ms Baker provided evidence that the LTCP includes the components of Hif1, and I've put the references in brackets, just as the LTP4 does. There is no inconsistency on a proper assessment. Mr Butler further told the inquiry that CP17 was fully compliant with paragraph 110 of the NPPF. He said that policy CP17 identifies the components of the Hif1 scheme to deliver growth in the southeast sub-area of the district, which includes land in the Science Vale, and which in turn will accommodate large housing and employment growth. His view was that whilst policy 17 may refer to LTP4, it advises the package of highway infrastructure will be refined through development of LPT4 and LPP2. His opinion is that it recognises that highway infrastructure identified in LTP4, which included the Hif1 scheme, could change. Whilst LTP4 was replaced with the LTCP still identifies the Hif1 scheme, and there was therefore no need to revise policy CP17 through the LPP2. Whether the package is refined through LPT4 or LTCP, or not at all, it makes no difference to the operation of this policy, as both those plans contain the relevant components of Hif1. Mr Turnbull also identified an inconsistency with paragraph 116 NPPF in his oral evidence. In cross-examination, he agreed that the inconsistency identified relates to the priority first to pedestrian and cycle movements. He agreed that when Part 1 was examined and adopted, NPPF 2012 was relevant, which included paragraph 35. Plans should protect and exploit opportunities for the use of sustainable transport modes for the movement of goods or people. Therefore, developments should be located and designed where practical to give priority to pedestrian and cycle movements and have access to high-quality public transport facilities. Both versions of national policy, whether 2012 or 2023, give priority to pedestrian and cycle movements. Mr Turnbull agreed that consistency with national policy would have been a matter for the examination inspector when assessing Part 1 for soundness, and policy CP17 was not found to be inconsistent. Ms Baker could see nothing materially different in the intention of either versions of the NPPF. Para 115 NPPF, Mr Tamplin's complaint made when giving evidence orally is that the plan is inconsistent with paragraph 115 due to impacts of climate change. As Ms Bowman told the inquiry, and with which Mr Butler agreed, paragraph 115 relates to severe effects in relation to highways and has nothing to do with climate change. If Mr Tamplin's argument was accepted, then any new highways infrastructure provided for in a local plan in accordance with paragraph 110 NPPF would conflict with para 115 NPPF. Turning to the overall weight to the development plan, and firstly the weight to the emerging joint local plan. Mr Tamplin gave the emerging plan moderate weight, Mr Turnbull gave it limited weight. It's not clear how or why there is a difference between parties jointly represented, but Ms Baker undertook a proper assessment in her evidence in chief under NPPF paragraph 48. Both Mr Tamplin and Mr Turnbull agreed that paragraph 48 was relevant to assessing the weight of the joint local plan, and I've set that out in full. It was agreed that the stage of preparation was early. It was agreed that as the consultation had only just closed, unresolved objections were unknown. This was further explained by Emma Baker, who gave up-to-date evidence to the inquiry that the consultation had recently concluded, so whilst it is clear that there are hundreds of objections, it's not clear to what extent. In terms of paragraph 48C, she explained that the councils hope that the policies are fully consistent, but there needs to be a review of stakeholder feedback. In summary, it makes little difference whether little or moderate weight is given to the joint local plan, because in terms of Hif1, the joint local plan has the same focus on development in the Science Vale area, and policy SP1 continued to focus on the Science Vale and Garden communities and relies on the housing and employment land suppliers allocated. The emerging plan safeguards the transport schemes, which include the components of Hif1 at Iron 3. Weight to the development plan. The Sutton Courtenay Neighbourhood Plan has now passed the referendum stage. That was on the 11th of April 2024, and it must therefore be made by Vale of Whitehorse within 8 weeks of the referendum. The neighbourhood plan is in force as part of the statutory development plan from the passing of the referendum and will have full legal effect when made by the local planning authority. This makes no difference to the strategy of LPP1 and LPP2 or the weight to the development plan overall. The LPP1 and LPP2 plans set out a clear spatial strategy, identifying in particular where homes and jobs are to be provided, and makes provision for the infrastructure needed to support them. The strategy and the policies were examined, and the plans were found sound, that is, in accordance with paragraph 35 NPPF. This is a relatively recent spatial strategy which has been reviewed and which is being taken forward in the emerging plan. It deserves full weight in the planning balance, and it is significant that the Hif1 scheme is required to deliver it. As Mr Butler told the inquiry, the most important policies for determining the application should be given full weight. Compliance with policy. Firstly, the principle of development. Policy CP17 of LPP1 identifies the Hif1 components needed to mitigate the impact of growth across the South East Vale sub-area. Policies CP18 LPP1 and CP18A safeguard land for Hif1. The proposal is compliant with CP17, 18 and 18A, and Hif1 is plan-led as required by paragraphs 15 and 114 NPPF. Sustainable travel. Policy CP33 is the relevant overarching policy engaged. The policy identifies 6 criteria that the Council will seek to achieve. And Madam, I've set those out in full and I don't read them. Mr Butler's evidence is that the Hif1 scheme is supported by criteria 1, 2, 3, 4 and 6. He had initially thought that criterion 4 was irrelevant, but in his evidence in chief, he told the inquiry that he had now considered the representation of Mr Marion of the Oxford Bus Company, which said that this package of bus service represents one of the most ambitious public transport network interventions anywhere in the county, or for that matter in southern England. They would transform the options for current and future residents of Didcot and wider South Oxfordshire to reach key employment destinations at Culham Science Centre, Arc Oxford, Oxford Science Park and the East Oxford Research Hospitals. Equally, in the opposite sense, the new bus routes that the scheme would facilitate would provide crucial connectivity from large parts of Oxford, including the key knowledge and research sites mentioned above, to other parts of the Science Vale UK cluster, helping to facilitate the agglomeration benefits of the cluster in a radically more sustainable manner. Mr Butler concluded that the letter indicates the proposals will support improvements for accessing Oxford in accordance with criterion 4. In terms of the other criteria, Mr Butler's written evidence is that the proposals seek to improve the local road network by providing additional capacity to accommodate traffic flows from planned development. The proposals provide for bus services together with pedestrian and cycle paths. These connect with existing and planned housing and with commercial developments providing residents and employees with options for sustainable travel rather than being reliant on the private motor vehicle. Examples provided are improved and sustainable transport links from new housing permitted and planned south of the A4130 Valley Park, Site 29, with commercial developments existing and or planned at the Didcot A site and Milton Park and Culham Science Park. In turn, Increased use of active travel improves health, and increased use of public transport can contribute to the improvement of air quality and reducing congestion. No safety issues have been raised, and Mr Butler in cross-examination was satisfied that OCC would not be promoting accident-prone routes. Policy CP35 is a district-wide policy which supports the Council working with OCC and others to promote the use of public transport, walking, cycling and efficient car use. Mr Butler confirms that 5 out of the 7 criteria are relevant, and the proposals comply with all because the provision of sustainable modes of transport can encourage a modal shift, and the new footways, cycleways and public transport opportunities provide accessible and sustainable links between existing and planned housing and commercial developments. This inquiry has heard a great deal from objectors about how new highways infrastructure will simply encourage more car use. There has been a failure to comprehend that this is not just infrastructure for vehicles. New highways infrastructure will lead to improvements in speed and reliability of bus services, encouraging use and patronage. The infrastructure includes new footpaths and cycle paths, which will encourage active travel, leading to the knock-on benefits identified. This is wholly compliant with the development plan policy. Landscape character and appearance. Policy CP44 provides that key features that contribute to the nature and quality of the landscape will be protected from harmful development and, where possible, enhanced. Whilst Mr Butler does identify conflict with Part 1 of Policy CP44 and SC3 of the Sutton Courtenay Neighbourhood Plan, and he gives moderate weight to the harm in views 7 and 13 in the Sutton Courtenay Neighbourhood Plan, he does qualify this conflict. Firstly, as he told the inquiry, this is not all beautiful, unspoilt, pristine, open countryside, and there are no designations affecting the countryside located within Vale of Whitehorse District Council. Secondly, the environment specific to Vale of Whitehorse District Council is relevant. The Hif1 proposals largely pass through urban areas, and part of the route passes through land identified as an enterprise zone and on which the Council is pursuing a local development order. The LDO is at an advanced stage of preparation and envisages a data centre and battery storage and buildings of up to 21 metres in height. The site is not in a designated landscape as it passes through Vale, and there are no important landscape settings to villages in this part of the Vale. The rural area between Site 23 and the River Thames already accommodates a railway, rail siding, landfill and mineral extraction works and haul road to them. Mr Butler also recognises that as LPP1 and LPP2 safeguard land for the development, the fact that there is potential for landscape and visual impacts has already been considered and has been found to be acceptable and/or necessary, given that the policies were found sound and are part of the adopted local plan. As a consequence, he confirms at paragraph 410 of his proof that this development is acceptable in principle and it is relevant to consider the measures proposed to integrate the development. It is accepted that due to the nature of the proposals, it is unlikely that landscape mitigation can hide the development or prevent any landscape or visual harm. This was also accepted by the landscape expert Ms Ash, who gave evidence on behalf of OCC. Whilst the scale of effects are not agreed between the main parties, Mr Butler is of the view that planning conditions can secure landscaping, including replacement trees and tree protection, to assist in reducing landscape and visual impacts. And conditions 6 and 7 could ensure that elements of the scheme, such as lighting and noise barriers, are designed to reduce landscape and visual effects. In terms of tree loss, Mr Butler has considered conditions 5, 9, 12, 17 and 18 relating to tree planting, a CMP, an LEMP, landscaping scheme and tree survey. He has suggested colours, transparent panels to be considered on acoustic barriers, climbing plants, vertical planting and general planting. There is residual harm, but this is to be expected and can be minimised. Mr Butler has listened to the evidence given on this topic throughout this inquiry, and he carefully considered the extent of the harm to be weighed in the planning balance. Turning to noise. Initially, Mr Butler had identified conflict with policies DP23 and DP25, and some conflict with criterion 5 of CP33. However, Mr Butler has now reflected on the evidence provided and heard at this inquiry and has modified his opinion. As he said, the only expert noise evidence provided to this inquiry was from Mr. Paget, who concludes at paragraph 417 that adequate mitigation has been provided to avoid significant adverse effects, mitigate and minimise adverse effects, and contribute to the improvement of health and quality of life. Mr. Butler notes that he is not an expert on noise matters and places weight on the conclusion at paragraph 418 of Mr. Paget's proof of evidence that the proposals comply with policies DP23 and DP25 of LPP2. In the absence of any contrary technical evidence on noise, including any evidence of his own, he revised his opinion and now concludes that the scheme is compliant with policies DP23, DP25 and Criterion 5 of CP33. Turning to design, policy CP37 and policy CP16B are both relevant. CP37 seeks high-quality design, and policy CP16B requires proposals in the Didcot Garden Town Master Plan area to demonstrate how they proactively contribute to the master plan principles, which include design, local character, density and tenure, transport and movement, heritage, landscape, green infrastructure, and social and community benefits. The Didcot Garden Town Master Plan is non-statutory and is not adopted policy. Mr. Butler places only limited weight on it. In short, the Council notes that the Master Plan encourages pioneering architecture, and it has been hoped that the Science Bridge could be a landmark feature. Mr. Butler's opinion is that the design is not pioneering. However, he told the inquiry that he had listened carefully to the evidence of both Mr. Blanchard and Mr. Chan, and he fully understood the construction constraints, including cost constraints and complex engineering constraints. He noted that a revised routing was considered, but was rejected, and he does not challenge that course further. The highest that the Council puts this is that it is disappointing, but it is understood. Furthermore, Mr. Butler is of the view that appearance could be improved via condition in order to ensure landscaping on approaches, hedge or shrub planting added to embankments, hawthorn and blackthorn as seen on many road embankments, consideration given to colour, texture, cladding, green walls, public art are all possible. Mr. Butler does not dismiss the possibility that the Science Bridge could still be an attractive landmark, and he considers that the proposals can, with conditions, comply with policy CP37 and CP16B. On biodiversity, the Council is satisfied that biodiversity net gain of at least 10% can be achieved. There is no adverse harm to designated sites or protected species identified. The proposals are compliant with CP46 of Part 1 and SC6 of the Neighbourhood Plan. On heritage, policies DP36, 37, 38 and 39 address heritage assets. The Council's Conservation Officer has identified no impacts on any heritage assets, and archaeology interest can be mitigated through conditions. The proposals comply with the relevant policies. On other matters in relation to other matters such as flooding, drainage, air quality, contamination, watercourses and public rights of way, Mr. Butler confirmed that he had not read or heard any technical evidence to persuade him that there are any other impacts that should justify refusal of the scheme. To conclude on compliance with the development plan, as Mr. Butler concluded in his oral evidence, when the development plan is read as a whole, the proposals comply with it and are in accordance with policies which are up to date and should be given full weight. Turning then to the first matter identified by the Secretary of State, the extent to which the proposed development is consistent with government policies for delivering a sufficient supply of homes as set out in NPPF. The spatial strategy of the local plan is the need to support the delivery of new housing and jobs to be complemented by new services, facilities and infrastructure. There are 3 sub-area strategies to give spatial expression to the strategy, including South East Vale, which includes much of the Science Vale area, as well as significant employment sites at Harwell Campus, Milton Park and Didcot A Power Station. The strategy will support the delivery of sustainable growth through 3 key strands as explained by Ms. Baker, focusing sustainable growth within the Science Vale area, reinforcing the service centre roles of the main settlements and promoting thriving villages and rural communities. In order to deliver sustainable growth, Figure 4.1 shows that there needs to be a comprehensive package of strategic and local infrastructure and services alongside the housing and employment growth, and that the delivery of high-quality development across Science Vale includes the provision of enabling infrastructure. The spatial strategy is underpinned by 5 core policies, of which Core Policy 4 of Part 1 and Core Policy 4A of Part 2 set a combined housing requirement of at least 22,760 homes for the district and cross-boundary needs. Total housing supply in Core Policy 4A is 25,359 dwellings, and if not completed, the same allocations and more exist in the joint local plan. Science Vale is a nationally and globally important hotspot for enterprise and innovation. Overall, approximately 70% of the predicted jobs and 75% of the strategic housing are to be delivered within the Science Vale ring-fenced area. Part 1, paragraph 4.44 states that essential strategic highway infrastructure has been identified to support the identified growth across Science Vale. Core Policy 15, Part 1, provides for 9,055 dwellings to be delivered through strategic allocations. Ms Baker explained that there are significant allocations in Vale of Whitehorse District Council linked to Hif1. Valley Park was allocated for 2,550 dwellings, but there is an outline planning permission for up to 4,254 homes. Northwest Valley Park is allocated for 800. Milton Heights was allocated for 400 and 458 homes have been permitted. West of Harwell Village was allocated for 200 homes and 207 have been permitted and completed. East of Sutton Courtenay, Hobby Horse Lane site was allocated for 220 and planning permission was granted on appeal in December 2023 for 175 homes. All these developments are in Science Vale. These allocations have been found sound to meet the housing need of Vale of Whitehorse District Council, which complies with the government objective of boosting the supply of housing. This development is already completed or underway. The examination inspector found in November 2016 that the transport impact study undertaken was not rebutted by any evidence to demonstrate that it was anything other than robust, and that the starting point situation for the Vale is as a district which very much suffers from traffic congestion. That was before housing was allocated, granted planning permission, or built. The need for housing is demonstrated through an up-to-date local plan found sound and adopted. The need for Hif1 is required to support that housing and the strategy, which is an integral plank of the local plan. Without Hif1, Mr Butler told the inquiry that the issues would be as followed. The planned enhancements for cycling, walking and public transport would not be forthcoming. The likelihood, with growth already permitted, is that more journeys would be undertaken by car. For developments already permitted in the area, for example 4,254 dwellings at Valley Park and 175 dwellings at Hobby Horse Lane, the developments would continue and likely add more congestion to the existing road network, resulting in gridlock. Congestion would further delay public transport. With the limited cycle and walking connections, these modes of travel would not be attractive and the anticipated modal shift would be highly unlikely. Reduced bus patronage would likely reduce service frequency. Increased congestion would add to the causes of climate change and increased pollution. Furthermore, for planning decisions, it is likely that OCC as Highway Authority would object to proposed development in the area, including those allocated in the local plan and which have yet to be permitted, for example Northwest Valley Park, and there is a risk these developments may not proceed. The housing, including affordable homes, may not be realised. Such a situation could also put the Vale in a position whereby it cannot show a 5-year housing land supply, which then risks unplanned housing growth in the district. That would be contrary to its plan and contrary to MPPF Para 15, which seeks to ensure that development is genuinely plan-led. As Mr Butler said, the Council would still need to decide applications against its adopted housing strategy and balance harm against benefits, and consequently, the Council could still permit, if it considered benefits outweigh the harm, housing on sites such as Northwest Valley Park, even though such development could continue to add traffic to a severely congested road network. These outcomes foreseen by Mr Butler are not consistent with government policies for delivering a sufficient supply of homes, as set out in the NPPF, risking either non-delivery, unplanned delivery, or housing without supporting infrastructure. Turning to the second matter identified by the Secretary of State, the extent to which the proposed development is consistent with government policies for building a strong competitive economy is set out in the NPPF. The strategy in the Vale of White Horse development plan for building a strong competitive economy in accordance with NPPF Chapter 6 is similar to and entwined with that for housing growth. It is focused on Science Vale and with the new housing growth to complement the economic strategy the jobs creation was forecast. Core Policy 15 of Part 1 sets out an employment provision of 208 acres for South East Vale, with much of this being within Science Vale. LPP1 explains that about 15,830 of 23,000 new jobs are located in the South East Vale area, with a number of significant centres of employment, including several sites in the Science Vale area, including Harwell Campus and Milton Park, designated as an enterprise zone in 2011. Science Vale is one of the key growth areas set out within the Oxfordshire Strategic Economic Plan and is the focus of significant investment. Core Policy 17, Part 1, lists the Hif1 scheme specifically as necessary to mitigate the impact of planned growth across Science Vale to secure the future economic viability of the area. Ms Baker told the inquiry that paragraph 85 NPPF is very relevant to justify the Hif1 scheme and underpins how the strategy for the Vale of White Horse District Council local plans respond to this part of the NPPF. She said that the strategy for Vale of White Horse encapsulates paragraph 85, seeking planning policies that help create the conditions in which businesses can invest, expand and adapt. Her evidence is that the development plan sets a strategy to bring about these conditions. Conclusions. Mr Butler undertook the planning balance both in writing and in evidence in chief. Whilst he notes some harms, these are limited and would have been recognised at the time that the local plan safeguarded land for this infrastructure. The Council's position is that the proposals fully comply with the development plan as a whole, and there are no material considerations indicating otherwise. Indeed, the proposals also comply with NPPF paras 8, 15, 60, 63, 74, 85, 110, 115, 116 and 180D. But to the extent that there may be any conflict with the development plan or other harm arising from this development, it's admitted that this is more than outweighed by its benefits, which include delivery of a significant amount of development meeting objectively assessed housing need allocated in the development plan and identified commercial land, housing and employment opportunities, investment in the local and wider economy through construction works, new residents and employees bringing economic benefits, housing including much needed affordable housing, sustainable travel links by public transport, cycling and walking between housing and commercial areas, the potential to reduce congestion by providing the sustainable, safer and more attractive travel links between commercial sites and housing to schools and between villages, encouraging less reliance on cars for journeys. The opportunity for less congestion and reliable bus services, for bus services to grow, and a modal shift to sustainable travel, which then benefits air quality and fewer carbon emissions. Opportunity to reduce traffic through villages, reduce noise for numerous local residents, new planting and biodiversity net gain, much needed improvement to Didcot, avoiding development moratoriums, enduring traffic pressures and poor connectivity. The benefits are, in the opinion of the Council's planning witness, Mr Butler, substantial. Importantly, not providing the proposals would exacerbate road congestion for permitted housing and employment in the Vale of White Horse district and jeopardise future housing development and commercial developments such as DTEC LDO in the enterprise zone. As Ms Baker sets out, a calculation undertaken in 2020 demonstrated that Hif1 would underpin at least 19,319 homes directly within South Oxfordshire and Vale of White Horse districts. That figure is now likely to be higher. Many interested parties who have spoken at this inquiry have realised the need for highways infrastructure. Mr Peacock told the inquiry that road infrastructure is woeful at the moment and needs to be improved. David Pry said that Hif addresses 3 key roadblocks. Our ancient travel infrastructure is choked. Jonathan Alcantara from the Cullen Bus Club gave powerful evidence about how his attempts to introduce more sustainable travel for the Europa school is still met sometimes with children on the bus for 2 hours instead of in education. James Barlow said that the district absolutely needs better infrastructure. Indeed, it has been obvious that even objectors recognise that housing and employment growth are needed and that a solution must be found. They do not support Hif1 as the solution, but provide no credible alternatives. Even if they had provided credible alternatives, given the policy support for the proposals, they are irrelevant, and it has not been demonstrated that there is any real possibility of any suggested alternatives coming about. They do no more than cast doubt. The arguments are further weakened by the lack of any real answer as to how alternatives would be funded in the absence of the housing infrastructure funding, which, as Ms Baker understands, was for this scheme only. The Council stresses that there is a significant strategic need and multiple benefits of the Hif1 scheme, and there is a relationship between significant levels of identified housing and employment in adopted and emerging local plans that are dependent on the delivery of the Hif1 scheme. Furthermore, the strategy for housing and economic growth in the joint local plan also relies on Hif1. In short, it is critical to housing and employment in the area and to the future of economic growth at Science Vale, and in maintaining public confidence in a plan-led system. And for all those reasons, the Secretary of State is respectfully invited to grant planning permission. Thank you.
So it's 11:45. I'm going to take a 15-minute break, and if we return at 12, I understand it was the UK. He's not here, but I'm sure he will be. He's outside, right? Thank you. So we'll return at 12. Thank you. Okay. Sorry, just before we hear from UK AEA, a couple of points over the break. First is the parish councils have responded and indicated that the way that I understand the objection to the orders is correct. So what we'll do, we'll add the original email to the website, but we won't have all the toing and froing on the website. Just, yeah. The other, which is a little bit more of an issue, is while we were sitting at about 11:35, May's Properties responded to the conditions discussion that we had on Friday. And they've actually put forward some revised wording to their suggested condition. I'm not going to ask you, Mr. Flanagan, to comment on that at the moment, but if you could consider it, and if you've got anything additional to add when we come to hear your evidence, perhaps after lunch, just respond on it if there's anything further. I think that's the way forward with that. In which case we're then ready to move forward, I think. Okay, so do you have a hard copy?
I do have hard copies, yes. I'll just hand them out, if I may.
Thank you. Thank you.
Okay, thank you, Madam. So, just move that microphone a bit closer. The United Kingdom Atomic Energy Authority, the UK AEA, appeared at this inquiry because the development of the UK AEA's headquarters at Culham campus is one of the foremost examples of why the proposed development hereafter the scheme is needed now. This position has been confirmed through the UK AEA's evidence to this inquiry, and planning permission for the scheme must be granted now to unlock the future development of the Culham campus and the national benefits which that development will deliver. If planning permission is not granted for the scheme, these benefits will be stifled and may be lost altogether. The scheme is long overdue, even more so after this inquiry. Any further delay will be intolerable, both for the UK AEA, the fusion sector in this country, and for Oxfordshire. There has been no meaningful challenge to the UK AEA's evidence. This is unsurprising. The UK AEA's evidence was robust, and the UK AEA's case is compelling in all respects. When given the opportunity to do so, the objectors to the scheme did not cross-examine two of the UK AEA's witnesses, and the questions that were put to Professor Sir Ian Chapman disclosed no credible or coherent arguments against the UK AEA's case. To the contrary, the cross-examination of Professor Sir Ian Chapman only served to highlight how robust his evidence was to the inquiry. And at this point, I must just pause, and in response to Mr. Woolley's closing for the objectors and their reference to Professor Sir Ian Chapman's oral evidence, effectively his paragraphs 4 and 5, it was inappropriate to put questions on highways matters to Professor Sir Ian Chapman, and those questions should have been put to Mr. Foxhall, but they were not. Professor Sir Ian Chapman addressed the matters to the best of his ability, but as I say, it was inappropriate to rely on those without regard to the evidence of Mr. Foxhall and the other transport witnesses called by Oxfordshire County Council. Returning then to my paragraph 5. Not only was there a failure to effectively challenge or even attempt to challenge the UK AEA in their case in cross-examination, but there was also a failure by the objectors to present any credible evidence against the UK AEA's position. To the extent that the objectors' evidence dealt with the UK AEA's case and Culham campus, it was obviously flawed. Essentially, a single argument was advanced, namely that there were alternative public transport solutions which would allow for further development at Culham campus. But like the objectors' wider arguments about alternative solutions, this argument was flawed in multiple respects. It follows that the UK AEA's evidence has demonstrated that planning permission should be granted for the scheme without delay, for the following 4 key reasons. Reason 1. There are existing highway capacity constraints on the highway network around Culham campus. Reason 2. The scheme is necessary to unlock the planned redevelopment of the Culham campus. There are no alternatives, either to the need for development at Culham campus or to the scheme. Reason 3. The future development of Culham campus, in accordance with the UK AEA's master plan, exemplifies sustainable development and will deliver a range of national benefits. Reason 4. The planning balance is overwhelmingly in favour of the grant of planning permission for the scheme. The last reason exemplifies the flawed and frankly unreasonable case presented by the objectors to this inquiry. The objectors accept that the scheme complies with the development plan as a whole. No contrary evidence has been presented. This is of critical importance. The fact of accordance with the development plan demonstrates that whatever the scheme's impacts, whether as assessed by OCC or as claimed by the objectors, they are acceptable in the round when assessed against the relevant planning policy. As a result, the scheme benefits from statutory presumption in favour of granting permission. There are no reasons to set aside that presumption in this case. Accordingly, the UK AEA submits that planning permission should be granted for the scheme without delay and invites UMAM to report to the Secretary of State that, on the Secretary's first issue, the scheme is fully consistent with government policies for delivering a sufficient supply of homes as set out in Chapter 5 of the NPPF. On the Secretary of State's second issue, the scheme is fully consistent with government policies for building a strong competitive economy as set out in Chapter 6 of the NPPF. On the Secretary of State's third issue, the scheme is consistent with the development plan for the area. And on the Secretary of State's fourth issue, the other matters which have been identified as relevant do not provide a basis for refusing to grant planning permission. Accordingly, the scheme benefits from the statutory presumption in favour of a grant of planning permission, as in Section 38(6) of the Planning Compulsory Purchase Act 2004, and there are no material considerations which justify a decision contrary to the development plan, and as such, planning permission should be granted. Turning to the 4 key reasons for granting that planning permission. Reason 1. There are existing and unacceptable capacity constraints on the highway network around Culham campus. The evidence before the planning inquiry demonstrates unequivocally that there are existing unacceptable capacity constraints on the highway network around Culham campus. Mr. Foxall identified 9 junctions near Culham campus which are already operating over capacity, of which 4 are particularly relevant because they restrict flows over 2 existing river crossings located at Clifton Hampden and Culham. The capacity exceedances at these junctions which Mr. Foxall identified are not marginal. To the contrary, they are significant, being well over the 90% target. Further, Mr. Foxall's technical evidence was consistent with the evidence of local people. For example, Mr. Pryor and Mr. Alcantara, who addressed the inquiry in the very first week. Indeed, even objectors identified the unacceptability of the present position. For example, Ms. Casey Rehay explained how congestion in Culham is an identified need for improvement. Her qualification that this was only at peak hours does not detract from the situation. The assessment of peak hour traffic flows is precisely the approach which must be adopted as a matter of best practice. The only person who disputed Mr. Foxall's conclusion that there were existing capacity constraints on the local highway network was Mr. James, and Mr. James' argument was flawed in multiple respects. in particular. Mr. James founded his argument on an addendum transport assessment dated the 24th of November 2021, ATA 1. This was prepared in support of an application by UK AEA for planning permission for a new research and development building on the campus. ATA 1 was superseded by a further addendum transport assessment dated the 31st of March 2022, ATA 2, in respect of the same building. Mr. James was not aware of ATA 2 when he prepared his written evidence. He did not address ATA 2 in his examination in chief, and, as he confirmed in cross-examination, he had not considered ATA 2 and its differences to ATA 1 before giving his oral evidence. In short, Mr. James has ignored the contents of ATA 2. This is an error of substance, as Mr. Foxall explained in his examination in chief, because ATA 2 does not support Mr. James' argument. In particular, ATA 2 concludes, consistently with Mr. Foxall's analysis, that there are existing capacity issues on the highway network which are unacceptable. For example, ATA 2 identifies existing capacity issues at the access to Culham campus, at the Clifton Hampden signals and the Culham River crossings. Excuse me. Further, and importantly, the analysis of ATA 2 was different to the analysis in ATA 1. For example, in respect of Clifton Hampden signals, ATA 2 identified a need for further mitigation, including from the scheme, which had not been identified in ATA 1. These are material differences which represent a finding of greater adverse capacity constraints than is identified in ATA 1. Again, these were matters which Mr. James had overlooked. In any event, even if ATA 2 was ignored, Mr. James' evidence was still flawed because he misunderstood the scope of ATA 1. ATA 1 was, very obviously, an assessment of the impact of the proposed research and development building only. ATA 1 was not an assessment of the impact of all of the development shown in the Framework Master Plan or all of the development planned in Policy Strat 8. It follows that ATA 1 is not evidence that the Culham campus can be redeveloped acceptably without the delivery of the scheme. Rather, it only demonstrates that acceptability of the delivery of the research and development building and, even then, in the longer term, forecasts that the scheme was taken into account as necessary mitigation. It follows that Mr. James has looked at the wrong document and, even in respect of that document that he did look at, he fundamentally misunderstood its contents. This is unsurprising, given he does not possess any relevant technical qualification, in stark contrast to Mr. Foxall, and the interpretation of the traffic modelling in ATA 1 and or ATA 2 is not within Mr. James' claimed expertise in sustainable transport planning. Accordingly, the correct conclusion is that there are existing capacity constraints on the local highway network near Culham campus. Further, the degree of constraint is exceeding the levels of congestion is already unacceptable. In light of this conclusion, the objector's argument about the veracity of the transport modelling undertaken by Oxfordshire County Council is a red herring. UK AEA's case is based on existing recorded constraints, not future modelled constraints. The fact that the constraints will only get worse without intervention, as OCC's modelling demonstrates, reinforces UK AEA's case, but it is not an essential component of its argument. Reason 2. The scheme is necessary to unlock the planned redevelopment of Culham campus. There are no alternatives, either to the need for the development of Culham campus or to the scheme. The effect of the existing capacity constraints is that there are already restrictions on the redevelopment of Culham campus. The planned future growth of Culham campus is that Culham campus was removed from the Green Belt by policies Strat 6 and Strat 8 of the South Oxfordshire Local Plan, the SOLP, for the express purpose of allowing the strategic development of the campus. The principle of significant future development of Culham campus is enshrined in the development plan. It is also supported by national policy in the UK Fusion Strategy. Policy Strat 8 expressly supports the redevelopment and intensification of Culham campus. The development envisaged by Policy Strat 8 is ambitious. The allocation is some 77 hectares. The redevelopment and intensification of the campus must deliver at least a net increase in employment land of 7.3 hectares when combined with the adjoining land, and the second largest single employment allocation in the SULP. And at the same time, the adjacent land, amounting to some 217 hectares, is allocated for around 3,500 homes by Policy Strat 9, the largest single housing allocation in the SULP. UKAA's ambition for the development of Culham campus is set out in the Framework Master Plan. As Mr. Sensical explained in his examination in chief, the Framework Master Plan envisages comprehensive redevelopment through to 2050 on a continuous basis. The Framework Master Plan is aligned with Policy Strat 8, as well as other relevant policies of the SULP. There is alignment between the Framework Master Plan and the UK's Fusion Strategy, the latter of which is particularly ambitious for the future development of the national interest at Culham campus, and to that end, the government has committed funding of some £184 million via the Fusion Foundations programme to support the transformation of Culham campus as envisaged in the Master Plan framework. Further, the UKAEA is already working closely with SODC and OCC as the local highway authority on the drafting of a local development order to facilitate the delivery of the ambitions in the Framework Master Plan. The need for the scheme then. The planned redevelopment of Culham campus, as shown in the Framework Master Plan and planned for in Strat 8, cannot be accommodated within the existing highway network, as Mr. Foxall explained in his evidence. This has been demonstrated by the recent planning history of the campus. As Mr. Sensical explained, recent planning permissions for development within Culham campus have only been granted because the UKAEA has traded floor space, i.e. it has given up some already permitted development in order to allow other development to be permitted. This approach has been necessitated because, and only because, of the inadequate road infrastructure which serves Culham campus. The trading of floor space cannot continue. It is an interim solution based on maintaining the status quo. It is not a long-term solution for planned growth. In addition, Mr. Foxall's conclusion is consistent with the development plan. The SULP explains that Culham campus has specific need for the scheme in terms. Culham campus cannot expand without necessary infrastructure, including the Didcot to Culham River Crossing and Clifton-Hamden bypass. More widely, the development plan also explains the importance of the scheme to the delivery of growth across Science Vale. This is a strategic priority for the county. The only solution to the inadequate highway capacity near Culham campus is the scheme. Mr. Foxall has considered each of the alternative solutions, and none are adequate. In particular, the physical constraints on the relevant junctions prevent meaningful changes to the layout and/or operation of those junctions in order to increase their capacity. This is especially the case in respect of 3 of the 4 junctions near Culham campus, which Mr. Foxall identified as being particularly important. Since June 2021, OCC has implemented an interim strategy, and the planned redevelopment of Culham campus in accordance with Strat 8 and the Framework Master Plan is not possible under this interim strategy. UKAEA has already made contributions towards public transport improvements. The provision of further financial contributions toward enhanced public transport provision will not provide sufficient mitigation for the delivery of all of the planned redevelopment of Culham campus. Further, and critically, the public transport improvements funded by such contributions need to be deliverable, but the evidence before this inquiry, in particular from Oxford Bus Company, demonstrates that meaningful public transport improvements are not feasible in the absence of the scheme. So too with additional cycling and walking provision, improvements to which require further infrastructure that will only be delivered by the scheme. Not only is the scheme necessary to address the overarching issue of highway capacity, but is also necessary to deliver 3 of the UK AEA's specific objectives for the redevelopment of Culham campus. First, the planned growth at Culham campus requires the construction of a second entrance and exit, and this is integrated into the scheme, specifically the Clifton Hampden bypass. This has been agreed as the most appropriate approach with OCC. Secondly, the modal shift that is a fundamental part of the UK AEA's vision for Culham campus is dependent on the new walking and cycling provision that is part of the scheme. Thirdly, the scheme will enable the delivery of a new main entrance to the Culham campus, which is more befitting of its status as a world-leading science and technology campus. Planning permission for this entrance has already been granted by SODC, but completion of the new entrance is dependent on the scheme, given the land shared between the developments. It follows that the scheme is needed to unlock the planned redevelopment of Culham campus. There is no other feasible solution. Turning to the flaws in the objectors' case on alternatives. The objectors have raised a multiplicity of arguments about alternative solutions. The starting point is to understand the correct approach to arguments based on alternatives. The objectors have consistently failed to understand the correct approach. Despite the legal principles being well established and despite those principles being highlighted by the UK AEA as well as other parties at this inquiry. The objectors have acted contrary to all those established principles and behaved unreasonably as a result. The UK AEA reiterates the following principles. The only statutory provision which requires consideration of alternatives in this case is Regulation 18.3D of the Town and Country Planning Environmental Impact Assessment Regulations 2017, the EIA regulations. That provision requires an environmental statement to include a description of reasonable alternatives, studied by the developer, and an indication of the main reasons for the option chosen. OCC, as the applicant, has plainly complied with this duty. Notably, the objectors did not cross-examine Mr. Maddox on this point. Aside from this statutory provision, an alternative scheme or site will only be a material consideration in exceptional circumstances. However, even in exceptional circumstances, where alternative proposals might be relevant, inchoate or vague schemes and or those that are unlikely or have no real possibility of coming about would not be relevant. The objectors advance 3 alternative arguments. The first argument is that there is one or more alternative to the scheme. The second argument is that the UK AEA should locate its development elsewhere. The third argument is that there are alternative transport solutions which can unlock the planned redevelopment of Culham campus. Applying the correct approach, each and every one of those arguments is unreasonable and flawed for the following reasons. First, the objectors have not identified or even attempted to identify the necessary exceptional circumstances to require consideration of alternatives to the scheme. Second, and in any event, the alternatives relied on by the objectors are vague and incoherent. There is no evidence that any of them will come forward. This was accepted in terms by Mr. Templin and Mr. Williams. It is also confirmed by the multiplicity of different suggestions made. There is no single evidenced alternative. Rather, objectors have simply made a multiplicity of generalised statements. This applies with even greater force to the alternative arguments about the development of Culham campus. Thirdly, the objector's case on alternatives was not based on any identified alternative, but instead on the contention that alternatives needed to be investigated again. This is untenable. There is no deficiency in the analysis already undertaken, and repetition of this analysis would only engender further delay. During that time, the already unacceptable congestion, including in Culham, would persist. This is a situation that is in nobody's interest, not even the objectors to the scheme. Fourthly, the specific arguments about Culham campus were based on basic misunderstandings of the UK AEA's work and redevelopment aspirations. The suggestion that the UK AEA either could or should move its operations elsewhere is untenable, as Professor Ian Chapman explained. To do so would be to lose all of the benefits inherent in the existing work at the campus and to lose all the benefits of clustering. Equally, the suggested reliance on public transport to unlock development at Culham campus is untenable. The UK AEA already has an ambitious travel plan that is aligned with the Local Transport and Connectivity Plan, LTCP. None of the objectors identified any deficiency in the travel plan, even when given the opportunity to do so. Indeed, Mr. James considered it to take modal shift very seriously. However, even with this ambition, the scheme remains necessary, as both the travel plan itself makes clear and Mr. Foxall explained. This is particularly the case in respect of improvements to bus and train services. Bus services will only improve when the congestion is resolved, such that they are commercially attractive. And train services will only improve when patronage increases. But that itself requires further housing, something which only this scheme can unlock. This is specifically the case in respect of Culham, as Policy Strat 9 expressly acknowledges. Finally, the suggestion of working from home more, a point only trailed in cross-examination of Sir Ian Chapman, showed a gross misunderstanding of the UK AEA's work, in particular the need for employees to be on-site to collaborate on ongoing research projects. It follows that there are no alternatives, either to the need for development of the Culham campus or to the scheme. The scheme is necessary to unlock the planned redevelopment of Culham campus. Reason 3. The further development of Culham campus, in accordance with UK AEA's master plan, exemplifies sustainable development and will deliver a range of national benefits. By permitting the scheme now, the future development of Culham campus will be unlocked and substantial national benefits will be secured through the future growth of what is already a facility of national as well as international significance. In January 1960, the UK AEA secured planning permission from OCC to develop the Culham site, then a formal naval airfield, as a research establishment. The laboratory, which covers some 80 hectares, was conceived, planned and built as a whole in the mid-1960s. The laboratory today remains largely as it existed then. The original complex of buildings still extends to approximately 59,000 square metres. As Mr. Sensical explained, the UK AEA has already embarked on a programme of redevelopment, but this still has a long way to go in order to deliver the facilities which the UK AEA, Oxfordshire and the UK require. The Culham campus is at the centre of fusion development globally. Not only is the Culham campus the headquarters of the UK AEA, the largest fusion research organisation in the world, but it is also home to a range of globally unique facilities. As a result, the Culham campus is the go-to place for both fusion research and private fusion companies. The private fusion companies already located at the campus and more are deciding to move to the campus. Professor Sir Ian Chapman explained to the inquiry that these companies encompass both innovative startups and some of the biggest commercial players in the sector. At present, some 3,400 people are employed at Culham campus across all organisations, of which 2,400 are employed by UK AEA. The level of employment is forecast to rise to 5,000 with the planned development of the campus. The importance of fusion development at Culham campus has been confirmed very recently in a letter directly to this inquiry from the Secretary of State for Energy Security and Net Zero. The letter bears rereading. The Secretary of State considers that Culham campus is key to our global advantage and that its development is entirely consistent with the UK's fusion strategy. In particular, the Secretary of State told the inquiry that a central part of the UK's fusion strategy is to grow Culham campus, taking advantage of its attractiveness as the centre for global fusion investment and firms that want to take advantage of the concentration of expertise and skills that such a centre brings. As the campus grows, it will become the natural home for global fusion research and development in the same way that Silicon Valley is the natural home for tech development. This supports the wider economic growth across the UK, given the geographical dispersal of the fusion technology supply chain in the UK. The Secretary of State also explained this position in earlier correspondence with the Department of Levelling Up, Housing and Communities about OCC's resolution to refuse planning permission before the application was called in. This letter also bears rereading. This decision by OCC to resolve to refuse planning permission has significant negative implications for the UK's ambition in fusion energy. As you will no doubt be aware, the UK is a global leader in fusion energy technology. The economic and environmental opportunities it could bring are enormous. We have a real opportunity for the UK to take advantage of a transformational emerging green technology and ensure that we don't throw away a strategic advantage decades in the making. At the heart of our global advantage is the Culham Science Centre for Fusion Energy. It has expertise and technical capabilities not found anywhere else on Earth. The UK's fusion strategy, published in 2021, seeks to make the most of this and develop the Culham campus into a global cluster for fusion in the same way that Silicon Valley is the global cluster for tech companies. This is not a wild ambition. Officials in my department are already talking to companies from the US, Sweden, Japan and Canada about locating at Culham. We are also in talks with international investors about significant potential investment in UK fusion. For all these organisations, Culham campus is the draw. Culham is not the only place that the UK AEA are investigating. They are building a new prototype fusion power plant in Nottinghamshire and have a technology hub at Rotherham. But it is the development of Culham campus that makes such investments possible. We are already planning on investing around 700 million in UK fusion in this spending review period and are in discussions with the Treasury to invest a further 600 million up to 2027, depending on the outcome of negotiations with the EU around participation in EU programmes. Without developing the Culham Science Centre, the benefits of these investments are at serious risk. The development plan also recognises Culham campus is the leading UK centre for fusion research and technology and is of international importance, with commensurate policy support for its growth. SODC has stated in terms the Council recognises the key role of the Culham campus site and supports and encourages its redevelopment. The benefits of redevelopment at Culham campus. The benefits of the redevelopment at the Culham campus are numerous and were not meaningfully challenged by objectors. In particular, redevelopment of the Culham campus is an exemplar of sustainable development. The redevelopment will use previously developed land in a sustainable location. Further, the redevelopment of Culham campus is the first step in ensuring the co-location of high-quality jobs and high-quality homes, as envisaged by policies Strat 8 and Strat 9, which will ensure the co-location of significant employment and housing growth at Culham. The redevelopment at Culham campus is an important driver for the Science Vale. The Science Vale is recognised as an international location for science and technology, which should continue to grow as a world-renowned science, research and innovation hub that attracts business, creates job opportunities and delivers housing growth. This ambition is embedded in the overarching vision and objectives of the development plan, and it is made real by the strategic policies in the development plan which make Science Vale the focus for major new development, including specifically at Culham. The work of the UK AEA at the Culham campus is the cornerstone of the UK's fusion strategy. The UK AEA is at the forefront of research into unlimited and climate-resilient energy creation. The fusion research programme at Culham campus is truly world-leading in managing the environmental effects of humankind. The Culham campus is a significant driver of inward investment into the UK and into the county specifically. This includes both public investment, such as the significant government funding for transformation of the campus, and also private investment. For example, through the more than 40 private companies who have chosen and are continuing to choose to locate themselves at Culham campus as part of the growing Fusion cluster. Linked to this investment, the redevelopment of Culham campus will deliver significant employment benefits. This is expressly recognised in the SALP, which considers the growth of the campus to support the objective to increase the number of high-quality jobs in the district. Taken together, this is a package of development which is truly of national and international scale. However, critically, this is a package of benefits that will only be realised in full when the redevelopment of Culham campus is unlocked by the scheme. Turning to the Secretary of State's first and second questions. These benefits are all in accordance with national policy. Accordingly, the UK AEA submits that the Secretary of State's first and second questions should be answered as follows. First, the scheme is consistent in all respects with the government's policies for delivering a sufficient supply of homes in the NPPF. As the district councils have explained, it is only through the delivery of the scheme that the necessary planned housing growth can be delivered and their respective housing supplies maintained. Accordingly, the scheme is the only way to significantly boost the supply of homes in the county, in accordance with paragraph 60 of the NPPF. Further, focusing on Culham specifically, the delivery of Strat 9, adjacent to Culham campus, with employment and housing co-located, is an exemplar sustainable housing development in accordance with paragraph 74 of the NPPF. Secondly, the scheme is also consistent in all respects with the government's policies for building a strong and competitive economy. The scheme satisfies each and every paragraph in Chapter 6 of the NPPF. The unlocking of future development at Culham campus exemplifies this consistency with the NPPF. For example, in respect of the overarching objectives in paragraph 85, the UK AEA and its associated cluster businesses can only invest, expand, adapt at the Culham campus if the scheme is delivered. The scheme is a necessary precondition to this economic development. There is a clear national need for the UK AEA and its associated cluster businesses to grow. This need attracts significant weight. So too the scheme, which is the only realistic way to meet that need. The Science Vale, of which Culham campus is a principal part, is an area of scientific innovation and strength. It too should be allowed to grow, and the scheme is necessary to remove the barriers to this growth. The work of the UK AEA at Culham campus is an area in which Britain is already a global leader. The position of strength can only be furthered and protected for the long term through the growth of Culham campus, an objective which depends on this scheme. Further, the delivery of the scheme is in accordance with paragraph 86 of the NPPF, especially subparagraphs A and C. The development plan contains a clear vision to support growth in Science Vale. However, that policy vision can only be delivered by the development of this scheme. This is exemplified by the Culham campus. The campus sits at the heart of Science Vale and is a key driver to its success. But its redevelopment to achieve those planned objectives is dependent on the scheme. The transport infrastructure, both in terms of highway capacity and to support sustainable transport, is a barrier to investment in the county. This is exemplified by Culham campus. Funding has been secured for its redevelopment, but this funding can only be utilised if the necessary infrastructure is in place to facilitate that redevelopment. Finally, the role of the scheme in unlocking redevelopment of Culham campus is in accordance with paragraph 87 of the NPPF. The need to redevelop the Culham campus is a good example of a sector having specific locational requirements, including the development of clusters, which are specifically contemplated by this paragraph of the NPPF. The campus is an established global centre in the fusion sector, and the benefits of its redevelopment, in particular the clustering of the UK AEA's research with others operating in the fusion sector, cannot be realised in any other location, as Professor Ian Chapman explained in his examination in chief. The flaws in the objector's case, and the only challenge to the UK AEA's case on this issue, was from Mr. Kirby, who asserted that the UK AEA had not fairly reflected the challenges facing fusion. Mr. Kirby was in error. Professor Sir Ian Chapman's proof of evidence is clear about the considerable scientific and engineering challenges in delivering fusion. Further, Mr. Kirby's representations failed to consider two critical factors. First, the advances in fusion science and technology over recent years, coupled with the advanced manufacturing and computing capabilities now available, mean that fusion energy is closer than ever before. And secondly, the national benefits which the Culham campus is already delivering, and will continue to deliver if further redevelopment is unlocked, and are realised on the journey towards a commercial fusion market. They arise from the scientific and engineering endeavour which is already underway, and which the planned redevelopment will further. Turning to the planning balance, and that it is overwhelmingly in favour of the grant of planning permission for this scheme. Remarkably, at the end of this inquiry, there is an apparent agreement that the scheme accords with the development plan when read as a whole. The objectors to the scheme have not even contested this critical point. Each and every planning witness for a party who supports the scheme has given their evidence with no challenge on this issue, and contrary evidence has not been presented by objectors. It follows that the answer to the Secretary of State's third question must be that the scheme is consistent with the development plan for the area. The conclusion is significant because the development plan contains a range of policies for assessing the acceptability of the scheme's different impacts, including those on local residents and the environment. In circumstances where there is compliance with that range of policies, the only proper conclusion must be that the impacts of the scheme are acceptable. Accordingly, whatever the various matters raised by the objectors, these are all immaterial in the final planning balance, because the scheme's impacts are acceptable when assessed against the adopted standards. Compliance with the development plan read as a whole is also significant because the scheme benefits from a statutory presumption in favour of the grant of planning permission. This is consistent with a raft of strategic policies which lend strong and unequivocal support to the delivery of the scheme. In the final planning balance, faced with the statutory presumption in favour of granting planning permission for the scheme, the objectors have relied on two allegedly contravening matters. The first of those matters is the argument about alternatives. That argument is flawed and must be accorded no weight for the reasons already explained. Indeed, the absence of any better alternative positively supports the scheme. The second matter is the extent to which the delivery of the scheme is consistent with the attainment of net zero and the decarbonisation of the transport network. This argument is also flawed and must be afforded no weight for the following reasons. First, the objector's argument was considered and rejected at the examination in public of the South Oxfordshire local plan. Consistency in decision-making requires the same conclusion here as the objectors have not... Consistency in decision-making requires the same conclusion here as the objectors have not shown or even attempted to show a good reason to depart from that previous conclusion. Secondly, the role of the scheme in achieving decarbonisation is made explicit in the LTCP, which specifically lists the scheme as a necessary measure to achieve its ambitious aims. Objectors cannot laud the LTCP without considering it as a whole. Quite simply, building the scheme now, including the new roads within it, is compatible with attaining net zero. Thirdly, the correct basis of assessment is to consider the net greenhouse gas emissions against the relevant carbon budgets. This was the approach in the environmental statement. It is an approach which is consistent with national policy, as Mr. Sensical has identified, and it is an approach which has been consistently upheld in the planning court. On this approach, the greenhouse gas effects during the construction of the scheme are acceptable, and when operational, the scheme will lead to the reduction in greenhouse gas emissions compared to a scenario where it is not delivered. This is a beneficial operational effect which supports the grant of planning permission for the scheme. It follows that the other considerations in this case do not support a departure from the development plan. To the contrary, they support the grant of planning permission for the scheme. It further follows that the planning balance lies in favour of the grant of planning permission for the scheme. This is the outcome which is very clearly in the best interests of planning and development in Oxfordshire, as well as the fusion sector in the UK. For the reasons given above, planning permission should be granted for the scheme without any further delay. Thank you very much.
Thank you. Can I just take a note of your name, because you're on behalf of Mr. Henderson?
Of course, yes, sorry. Peter Canavan, C-A-N-A-V-A-N.
Sorry, C-A-V-A-N?
C-A-N-A-V-A-N.
Right, thank you.
Thank you very much.
Are you from the same chambers, or...?
No, I'm a planning consultant. So I'm from Carter Jonas.
Thank you for that. It's 10 to 1, so I think that's a sensible point to break. We could, do we want an hour or do we want 45 minutes? 45 minutes, right. We come back about 25 to? Yeah, thank you. So the inquiry's resumed. Is everybody here that needs to be here, or are you waiting? Anybody waiting? No? Mr. Ing. Oh, take care.
I'm going to get one extra hard copy.
Thank you. Thank you.
In his statement to the inquiry, Councillor David Ruane, the leader of South Oxfordshire District Council, described the Hif1 scheme as a fundamental part of our local plan. He said that during the examination of the plan, it was made clear to the council that without it, our local plan would fail because so many housing sites, planned and existing, need this road in order to be viable settlements. It is therefore no surprise that the South Oxfordshire local plan explicitly supports the delivery of the Hif1 scheme in Policy Trans 1B. The land needed to deliver the road is safeguarded in Policy Trans 3 and Appendix 5. The relevant strategic housing policies emphasise the need for this infrastructure. The SALT provides strong support for the principle of the development. Although there were many objections to the local plan, that battle has finished. The plan is adopted and it now needs to be delivered. That includes the Hif1 scheme, which is key to delivering existing and planned growth. South Oxfordshire District Council strongly supports this planning application. The Hif1 scheme is plan-led development, which is needed to support large-scale plan-led housing and employment growth. It will deliver huge benefits. It is essential that permission is granted without delay so that those benefits can be realised. These submissions address matters A to C identified by the Secretary of State in his letter dated 25th of July 2023, in which he confirmed that he was exercising his power to call in the application for his own determination. They also address most, but not all, of the main issues identified by you, Madam, in your letter of 12th of January of this year. Need for the scheme, delivering planned housing growth. The spatial strategy of the SALP includes focusing major new development in Science Vale so that this area can play an enhanced role in providing homes, jobs and services with improved transport connectivity and providing other strategic allocations, including at Berensfield, with necessary infrastructure and community facilities. To implement that strategy, the local plan makes several strategic allocations, including those in policies Strat 3 and H2, Strat 9 and Strat 10.1. Together, these policies allocate land for 10,199 new homes within the current plan period. To put that figure into context, it's close to half the minimum housing requirement for the entire plan period and a third of the total housing supply identified in the plan. Some of the Didcot allocations have already been consented and or delivered, despite Hif1 not being in place to mitigate their impact. That's in addition to several very large developments which are committed or delivered around Didcot in neighbouring Vale of the White Horse. But 1,400 homes are yet to be built on sites around Didcot in South Oxfordshire's area. All of the planned development at Culham and Berensfield is still to come. The inspector who examined the local plan concluded that the Hif1 scheme was necessary to support the new housing planned around Didcot and at Culham and Berensfield. His report identifies that the Hif1 scheme must be delivered prior to any significant development at Culham, that it needs to be in place prior to the commencement of development at Berensfield, and that it will enable infrastructure to support key development sites in and around Didcot. The position is confirmed by the adopted policy wording, which expressly links the delivery of the houses to the provision of planned infrastructure, including Hif1. Policy Strat 3, paragraph 3, refers to the significant infrastructure improvements committed to under Trans 1B and states that infrastructure will need to be in place to enable sites allocated in the local plan in and around Didcot to be delivered. Policy Strat 9, paragraph 2.6, requires development to deliver necessary infrastructure, including the Hif1 scheme. Paragraph 6 states that the number and phasing of homes to be permitted and the timing of housing delivery linked to the planned infrastructure needs to be informed by further evidence. This will be agreed and potentially conditioned through the planning application process. And policy Strat 10.1 contains identical wording to Strat 9. More broadly, the Hif1 scheme was included as part of the planned highway mitigation for planned housing and employment growth in the traffic modelling, supporting the soundness of the local plan. The July 2020 Evaluation of Transport Impacts Stage 3 report tested the transport impacts of an additional 30,168 dwellings in South Oxfordshire's area over the plan period. That compares with the final housing supply in the adopted plan of 30,056 homes. Each of the elements of the Hif1 scheme were included as part of the highways mitigation within the model. Thus, the transport evidence base supporting the planned growth in South Oxfordshire's area is based on the assumption that Hif1 will come forward. Emma Baker explained further that during the examination of the SOLP, the inspector requested further information about the housing coming forward in the Didcot Garden Town area. The County Council produced a note confirming that 19,319 houses had been included in the modelling for the Didcot Garden Town area of influence, plus Berensfield. This includes land within both South Oxfordshire and Vale of the White Horse. Ms Baker pointed out that there have been additional windfall developments in the 4 years since that note was produced. Such developments will continue to come forward. A recent example is the development of approximately 150 houses at land at Lady Grove, which was allowed on appeal. It's therefore clear that in addition to the strategic allocations which are yet to be delivered in South Oxfordshire's area, the Hif1 scheme is necessary to support what Ms Baumann described as unprecedented levels of growth in the Didcot Garden Town area. Given the evidence about the existing road network discussed later, it's fanciful to suggest that such high levels of housing growth can be delivered without some significant new highways infrastructure to support it. In fact, there is widespread agreement that some additional infrastructure is needed. Many local people who oppose the scheme nevertheless acknowledge that infrastructure is needed and that something needs to be done. The objections are mainly to the solution which has been chosen, rather than questioning the need for a solution at all. Delivering planned employment growth. The Hif1 bid was predicated on unlocking housing growth, and the business case did not therefore rely on any employment growth. Nevertheless, the local plan plans for significant employment growth in the Didcot Garden Town area. The strategic housing allocations at Culham and Berensfield both include land for employment use. This is also referred to in policy EMP1. At Culham, a net increase of 7.3 hectares of employment land is sought from Strat 8 and 9 together, in addition to the existing 10 hectares at the number 1 site immediately east of the railway line. A recent consultation document published by CEG indicates that the developer will shortly be bringing forward a proposal for 11.5 hectares of employment land at the number 1 site. At Berensfield, the allocation includes at least 5 hectares of employment land. This employment development is subject to the same policy wording as the housing developments which are planned for these locations, and is therefore expressly linked to the Hif1 scheme in the same way. In addition, policy EMP1 identifies 6.5 hectares of employment land at Milton Park in the Vale of the White Horse, which is required to meet cross-boundary employment needs. This is in addition to the 28 hectares of employment land included for Milton Park in the Vale local plan. In selecting these locations for employment growth, South Oxfordshire District Council has sought to make a strong link between the housing growth in Didcot and the business growth needs of Science Vale, and has sought to allocate employment land within strategic housing allocations to enable the creation of sustainable communities and to provide new residents with the chance to work locally. This is all consistent with South Oxfordshire's strategy and priorities for Science Vale, which include providing an environment in which science-led business can flourish. As with the housing growth, employment growth across the plan period was included in the modelling which underpinned the SOLP. The final stage of the evaluation of traffic impacts, stage 3, modelled 4,282 jobs within South Oxfordshire's area. Again, the Hif1 scheme was included within the model, providing an indirect link between the employment growth and the need for Hif1. More direct evidence was provided by Stephen Sensical on behalf of UK AEA. He also acts on behalf of CEG, the promoter of the Strat 9 allocation. He confirmed that planning permission for the employment proposal coming forward on the number 1 site is expected to be subject to a Grampian condition limiting development by reference to the Hif1 scheme. He also explained how UK AEA's ability to develop the Culham campus has been limited by the county's position on highway capacity, recounting that it had been necessary to enter into a Section 106 to trade floor space from existing outline consent to bring forward reserve matters on a more urgent development to address this issue. His evidence reflects what is stated explicitly in the SOLP. CSC cannot expand without necessary infrastructure, including the Didcot to Cullen River crossing and Clifton Hampton bypass. Addressing existing highway conditions. Several witnesses gave evidence of the conditions which are currently experienced on the highway network and the lack of resilience in the system. It's not necessary to rely on transport modelling to understand this evidence. The inquiry has heard repeated evidence about the bottlenecks which exist at the Cullen and Clifton Hampton bridges, even in normal peak conditions. This is exacerbated when one or both bridges are closed due to flooding or for repairs. The evidence from John Alcantara and Sue Skane was particularly compelling. Mr Alcantara runs the Cullen Bus Club and explained that children have to sit on a bus in a queue to cross Cullen Bridge for at least 20 minutes per day, and that the bus club have had to shift pickups earlier, sometimes to before 7 a.m, due to the congestion. He said that during recent floods, children ended up sitting on buses for 2 hours trying to get to school. Ms Skane runs the Didcot Volunteer Drivers Group, which takes people to medical appointments. Her service is also affected by delays, bridge closures and unreliable journey times. These are real-world impacts which affect real people's lives and which a model cannot capture. The problems with the existing highway network were also made clear in the series of appeal decisions in 2018 to 19, where inspectors upheld refusals of permission for single dwellings based on the impacts of additional traffic on the network. In one of these decisions, the inspector commented that the residual cumulative impact is already severe without the proposed development. Such concerns ultimately led to the development of the Releasing Development Strategy. The Associated Cabinet report discusses the difficult tensions between the county's role and responsibilities in respect of network capacity and the implications for the district councils in terms of meeting housing needs and maintaining housing supply. The report confirms that in the absence of the Hif1 infrastructure, much of the highway network is at design capacity during the morning and evening commute times, but recognises the overall national planning gain in delivering houses. The strategy involves the county not objecting to developments of 10+ houses that will generate new peak traffic movements on the basis that Hif1 funding has been secured and OCC is confident in delivering Hif1. It provides that occupation controls will be applied to development sites to lessen the cumulative impact on the highway network. That strategy has allowed some development to come forward at Lady Grove East. 250 of the consented 750 homes can come forward in advance of Hif1. The remainder is subject to an occupancy restriction, but clearly this is not a long-term solution. Benefits of the scheme: delivering planned housing growth. The government's stated objective is to significantly boost the supply of homes. The delivery of necessary infrastructure to unlock the high levels of planned housing growth in the Didcot Garden Town area is clearly the most significant benefit of the Hif1 scheme and must attract a high level of weight. Hif1 is fully consistent with the government's policies for delivering a sufficient supply of homes. Throughout the preparation and examination of the local plan, it was assumed that the Hif1 scheme would come forward. In fact, it was anticipated that it would be delivered by 2024. The existence of this important highways infrastructure underpins the soundness of the allocations and the wider spatial strategy. In her evidence in chief, Ms Baumann emphasised the importance of this housing growth being plan-led. Paragraph 15 of the framework provides that the planning system should be genuinely plan-led and that succinct and up-to-date plans should provide a positive vision for the future of each area. This is exactly what the SOLP does. It sets a vision and strategy for housing and employment growth to be focused in the Science Vale, building on the existing success of this area. It provides for the necessary infrastructure to facilitate and support that growth, and Hif1 is a fundamental element of that. If the strategic sites around Didcot and at Cullen and Berensfield are to be delivered in a plan-led way, then it necessarily follows that Hif1 needs to be delivered. Affordable housing. Ms Baumann gave some important evidence about the affordability issues facing South Oxfordshire and the need for more affordable housing. The provision of affordable homes to meet local needs is one of the Council's corporate priorities. She confirmed that the large allocations at Cullen and Berensfield are expected to make up the bulk of affordable housing delivery once delivery commences. Those two sites alone are expected to deliver 5,200 homes. There is a proposal within the emerging plan to require 50% of dwellings on such sites to be affordable. But even if the current policy requirement for 40% were to remain, this would equate to 2,080 affordable homes from these two sites. The Hif1 scheme will unlock delivery of these much-needed homes, and this is another significant benefit of the scheme. Delivering employment growth. Professor Sir Ian Chapman and Stephen Sensical both spoke compellingly about the nature and scale of the economic benefits which would flow from the planned growth at Culham. The Hif1 scheme will also support significant levels of economic growth at Berensfield and Milton Park. Madam, I then set out paragraph 85, which I won't read. As Ms Baker confirmed, this is directly relevant both to the strategy of the local plan and what it is seeking to achieve, and specifically to the Hif1 scheme. The Hif1 scheme will help to create conditions in which businesses can invest and expand. Hif1 is clearly needed to support economic growth and productivity in the Science Vale. It will allow what is already a site which is recognised as being of international importance to build on its strengths and address challenges of the future. Significant weight should therefore be placed on this benefit. The Hif1 scheme is fully consistent with government policies for building a strong competitive economy. Addressing existing highways issues. The evidence presented to the inquiry is that Hif1 would address the current conditions faced on the local highway network in three key ways. It would provide more capacity and thus relieve congestion which is currently experienced in pinch point locations. The Rule 6 objectors have advanced a case that 10 years after the Hif1 scheme is opened, the traffic picture on the network would be approximately the same as the day before the road opens, so that sooner or later conditions will deteriorate to the point where the benefit of Hif1 is lost. However, this fails to recognise the important fact that by that time, the Hif1 scheme will have facilitated significant amounts of planned growth. As the county have emphasised, the Hif1 scheme is not proposed as a complete and for all time solution to congestion. It's intended to facilitate a level of planned growth, which is what it will achieve. The Hif1 scheme provides an important additional river crossing, which will help address the issue of severance between Didcot and the Culham campus, and more generally between Didcot and areas to the north of the Thames, where significant housing growth is planned. This severance affects all modes of transport. Although falling outside South Oxfordshire's area, the Science Bridge will also help to address severance caused by the railway line. By providing an additional river crossing, the Hif1 scheme will also help to improve the resilience of the local transport network. Many witnesses have spoken about this issue and the impact on the network when there's an event such as flooding or an accident or road closure. Delivering improvements in active travel and public transport. Policy Trans 2 states that South Oxfordshire will, among other things, work with the county and others to ensure new development is designed to encourage walking and cycling and support sustainable transport improvements in the wider Didcot Garden Town area and in and around Oxford, particularly where they improve access to strategic development locations. Policy Trans 5 applies to consideration of development proposals and requires developments to provide safe and convenient routes for cyclists and pedestrians, both within the development and including links to rights of way and other off-site walking and cycling routes where relevant. The Hif1 scheme meets the aims of these policies. It's not just a road scheme. It also provides a walking and cycling route which will be segregated for most of its length. Ms Bauman's assessment is that this will be a high-quality provision and will provide a genuine alternative to the private car. The Rule 6 objectors compared this aspect of the Hif1 scheme unfavourably to the garden line, which was originally illustrated in the Didcot Garden Town delivery plan. But there was never any adopted plan or policy to deliver the garden line, and the proposal was later removed from the reviewed delivery plan, as Mr Tamplin acknowledged. In any event, the objectors who mentioned this proposal may have been somewhat mistaken as to what it actually involved. The delivery plan makes clear that it was largely a case of upgrading existing routes. Emma Baker's assessment was that she saw the garden line in the Hif1 scheme. Certainly the walking and cycling provision associated with the scheme is a vast improvement on the existing routes between Didcot and Culham, particularly for cyclists. Indeed, Mr Williams agreed that it was far better than what exists currently. The walking and cycling benefits associated with the Hif1 scheme do not stop at the red line boundary. It's important to appreciate, as some of the speakers objecting the scheme failed to do, that the Hif1 scheme is just one part of a wider walking and cycling strategy. By bringing forward the strategic housing allocations at Culham and Berensfield, the Hif1 scheme will unlock further active travel improvements in the area. Policy Strat 9 will require the housing-led development to deliver provision for excellent sustainable transport facilities, including, but not limited to, new and improvements to existing cycle and footpaths, including provision of a new cycle bridge and associated connectivity and paths across the River Thames to connect appropriately with Abingdon. The CEG consultation document produced by Ms Baumann shows this indicatively. Together with the Hif1 scheme, this would result in an almost fully segregated cycling route from Didcot all the way through to Abingdon. The consultation document also shows the potential for other cycle connections through the Strat 9 and Strat 8 sites. Similarly, Policy Strat 10.1 will require the strategic development at Berensfield to deliver high-quality infrastructure to encourage cycling and walking and provide links through the site and to adjacent employment and into the village of Berensfield and to other surrounding locations including Culham, specifically but not limited to improving the existing pedestrian cyclist infrastructure along the A415 from Berensfield to Culham and providing for a cycle route from Berensfield to Oxford. In addition to the cycling and walking improvements that would be delivered and unlocked by the Hif1 scheme, there's also been evidence of the improvements for bus travel. Again, there are benefits delivered by the Hif1 scheme itself and knock-on benefits which will be unlocked through the delivery of the strategic allocations. The scheme itself will improve bus travel by providing additional highway network capacity, which will make the highway network more resilient and improve journey time reliability, addressing one of the major barriers which currently exist to increased bus patronage, and incorporating bus priority measures via the imposition of a suitable condition, which will also improve journey times. All of this will make buses a more attractive option than is currently the case. As with the walking and cycling provision, by unlocking development on Strat 9 and 10.1, the Hif1 scheme will indirectly lead to further improvements in bus provision within the Science Vale area. Policy Strat 9 requires development to deliver bus improvements, including provision of a scheduled bus service with a minimum of 2 buses per hour between Berensfield, Culham and Abingdon, with options to extend or vary services to locations such as Cowley, Chalgrove and Didcot. Whilst Policy Strat 10.1 will require the Berensfield development to pump prime the same services. Finally, Policy Strat 9 also requires development to deliver contributions to Culham station improvements, including longer platforms, public realm, new station building and potentially car parking. Mr Wisdom described these station improvements in more detail in his proof. Both Ms Baker and Mr Wisdom also confirmed that the delivery of large amounts of housing at Culham would support the business case for improved rail frequency there. Alternative ways of meeting the need and delivering the benefits. Some of the witnesses for the Rule 6 objectors and some other interested parties have suggested that Hif1 is not essential and that the planned housing growth in this area can be unlocked with other transport solutions or plans based on active travel or public transport improvements. There's a well-known body of case law dealing with the circumstances in which alternative proposals may be material considerations. The relevant legal principles were summarised in the Mount Cook case, and the key points identified include that in the absence of conflict with planning policy and or other planning harm, the relative advantages of alternative uses on the application site or of the same use on alternative sites are normally irrelevant in planning terms, and even in exceptional circumstances where alternative proposals might be relevant, inchoate or vague schemes and or those that are unlikely or have no real possibility of coming about would not be relevant, or if they were, should be given little or no weight. The Council's case is that the Hif1 scheme is clearly in accordance with the development plan as a whole and is acceptable. Therefore, the prospect of any alternative schemes is irrelevant. Even if the various alternatives advanced by the objectors were in principle material considerations, there's a complete lack of detail or evidence as to their feasibility. Crucially, there is no evidence whatsoever to substantiate the suggestion that an alternative scheme, which did not include a new road, could provide mitigation for the planned housing growth. Mr Tamplin fairly described his evidence on alternatives as a back-of-a-fag packet, very simplistic assessment, and said that he was not putting forward any worked-up feasible alternative. That applies equally to the evidence of other objectors on that issue. The suggested alternatives are all inchoate or vague schemes that have no real possibility of coming about and so cannot carry any weight. As already mentioned, the local plan seeks to prioritise active travel modes and ensure that new housing development secures and delivers improvements in walking, cycling and public transport. Active and sustainable travel is by no means ignored by either South Oxfordshire or the county. But in a rural area like this, car use will inevitably remain part of the picture. It's clearly unrealistic to suggest that the level of growth can be accommodated without new road capacity, given the evidence the inquiry has heard about the current highway conditions. Ms Baker also pointed out that the Hif1 scheme has funding as a result of the competitive bid process, and her understanding was that if the Hif1 scheme is not delivered, that funding will be lost. There is, of course, no suggested funding mechanism to support any of the alternative plans and schemes identified by objectors. Aaron Wisdom said that it would be completely irresponsible to refuse the well-planned, widely supported Hif1 scheme on the basis something may turn up. South Oxfordshire agrees with this assessment. The Green Belt. The precise location of the Green Belt boundary can be usefully identified from a comparison between Sheet 2 of Bernard Greep's Appendix 2.2 and the first plan in Appendix 4 of the local plan, showing land inset from the Green Belt for the purposes of the Strat 8 and 9 allocations. This confirms that the bridge over the River Thames, together with the viaduct and embankment where the road lands on the north bank of the river, is within the Green Belt, as is the stretch of road leading to the new A415 junction and the Clifton-Hampton bypass. I then set out paragraphs 152 to 153 of the framework, which I won't read out. That long-standing national policy approach finds reflection in Policy Strat 6 of the local plan. Inappropriate development and Green Belt impact. Mr Greep's evidence raised the issue of whether the Hif1 scheme may benefit from paragraph 155C of the framework, in which case it falls within a category of development which is not inappropriate in the Green Belt. In that scenario, very special circumstances would not be required. Paragraph 155C provides that local transport infrastructure which can demonstrate a requirement for a Green Belt location is not inappropriate, provided it preserves openness and does not conflict with Green Belt purposes of including land within it. There appears to be no dispute that the Hif1 scheme constitutes local transport infrastructure. There's also been no serious challenge to the issue of whether Hif1 can demonstrate a requirement for a Green Belt location, given that any road scheme linking Didcot to the Culham strategic sites and bypassing Clifton-Hampton will inevitably have to pass through the Green Belt. On this point, Mr James identified that the only dispute is whether the road is necessary, but that is not a relevant question under paragraph 155C. The question is whether there is... That doesn't really make sense. I think I've missed some words. The question is not whether there is a requirement for the development, but whether the development requires a Green Belt location. Clearly it does. The key issue between Mr Greep and Ms Bowman is whether the Hif1 scheme will preserve openness and not conflict with Green Belt purposes, specifically Purpose C. The area of disagreement is narrow because Ms Bowman expressly agreed with the logic of Mr Greep's approach. If paragraph 155C is to have some purpose and not be self-defeating, some level of local transport infrastructure must be capable of falling within its scope. Given that development of this type will almost inevitably have some impact on openness, the existence of paragraph 155C necessarily implies that some degree of impact must be acceptable. It's common ground that the question of where the tipping point lies is a matter of planning judgment. Ms Bowman judges that elements of the Hif1 scheme, which lie within the Green Belt, have impacts on openness and purposes which go beyond that tipping point. Mr Greep takes the opposite view. These are both legitimate professional judgments. Very special circumstances. If the Secretary of State agrees with Ms Bowman's judgment on paragraph 155C, it follows that the Hif1 scheme, insofar as it's located in the Green Belt, is inappropriate development. Such development is harmful by definition, and that harm must be given substantial weight. Ms Bowman's assessment is that the substantial public benefits of the Hif1 scheme, which she ran through and which I've summarised above, clearly outweigh the harm to the Green Belt and any other harm. There can be no doubt that very special circumstances exist. Her planning judgment on this issue was not challenged by the Rule 6 objectors. Somewhat surprisingly, Mr James was the only witness for the Rule 6 objectors who sought to address the impact on the Greenbelt at all. In cross-examination, he confirmed that if it's concluded that a level of housing development that is sustainable cannot go ahead without Hif1 or some sections of it, then it would be a valid conclusion that very special circumstances exist. It's not for this inquiry to consider what level of housing growth is sustainable or what infrastructure needs to be planned for to support the delivery of that growth. Those are matters which have been fully assessed through the local plan examination, and the plan was found to be sound. It necessarily follows that the level of housing growth planned for the Science Vale is sustainable. Therefore, on the Rule 6 objector's own case, the Greenbelt impact does not constitute a reason for refusing planning permission. Ms Baumann expressed the view that it would be a bizarre situation if exceptional circumstances existed to justify removing the land at Strat 8, 9 and 10-1 from the Greenbelt, but the infrastructure needed to deliver those allocations was prevented due to its Greenbelt location, and Mr Greep agreed with that argument. Other matters relevant to the planning balance. Matters raised by South Oxfordshire's full council. On the 29th of August 2023, the full council of South Oxfordshire resolved to ensure that its views were properly represented at the inquiry and identified a number of issues which it particularly wished to address as follows. The importance of infrastructure funded by Hif1 to the delivery of housing and economic sites allocated in the adopted local plan 2035. South Oxfordshire's target of becoming a net zero district by 2030. The need for high quality design throughout, as set out in the design guide in the Didcot Garden Town Delivery Plan. Minimising harmful impact of any scheme on our natural and historic landscape, including the River Thames, and maximising biodiversity. And respecting the views of affected communities, including both Didcot and the surrounding villages. Point 1 has been addressed above by reference to the need and benefits of the scheme. Points 2 to 4 are discussed in this section. As to point 5, the inquiry has heard from the affected communities both through the Rule 6 objectors and also through individuals who have attended and spoken for and against the scheme, in addition to the written representations and consultation responses. South Oxfordshire respects all of these views. The position it has taken in response to the Hif1 scheme is in accordance with its own adopted policies and is judged to best serve the interests of all residents. Climate and sustainability. Policy DES 8 requires new developments to seek to minimise the carbon and energy impacts of their design and construction and demonstrate that they are seeking to limit greenhouse gas emissions. Mr Lansborough's evidence was that during the construction phase, Hif1 will have minor adverse, not significant effects in terms of greenhouse gas emissions. However, once operational, the Hif1 scheme is estimated to reduce greenhouse gas emissions compared to the baseline scenario, with a minor beneficial effect on emissions. That was not undermined by Dr Ng's evidence. As set out in Ms Baumann's proof, South Oxfordshire welcomes proposed conditions 25 and 36 relating to carbon management plans. Ms Baumann confirmed her assessment that with such conditions, the Hif1 scheme complies with Policy DES 8. High quality design. Policy DES 1 provides that all new development must be of high quality design, whilst Policy DES 2 requires development to physically and visually enhance and complement the surroundings and respond positively to the site and its surroundings. In applying these policies, it has to be borne in mind that Hif1 is a road scheme and must meet relevant technical and safety specifications. Form is to a very large extent dictated by function. The scheme will by its very nature have an engineered appearance in places, particularly in the short term. South Oxfordshire's landscape officer raised some concerns about the design of the Science Bridge, which is close to but outside its area. Ms Baumann described the bridges as a bit of a missed opportunity, although it was clear from Mr Blanchard's evidence that there were several constraints relating to the design of the structure. Concern was also raised about the Thames Crossing Bridge and viaduct, in particular the bulky appearance of the supports. Again, Ms Baumann recognised that the bridge will inevitably be engineered in appearance. She was satisfied that a landmark feature would not be appropriate in this rural setting. Draft Condition 8 would require submission and approval of details of the external appearance of both bridges, which would provide an opportunity to ensure that the materials, finishes and colours used will enhance the appearance of the Science Bridge and reduce the prominence of the Thames crossing as far as possible. Ms Bauman's overall view was that the design of both bridges was acceptable and would not result in any policy conflict. Landscape impact and biodiversity. Policy ENV1 seeks to protect South Oxfordshire's landscape, countryside and rural areas from harmful development and requires development to protect and, where possible, enhance features that contribute to the nature and quality of the landscape, including the landscapes, waterscapes, cultural heritage and user enjoyment of the River Thames. Policy DES 2 is to similar effect, requiring development to be designed to reflect the positive features that make up the character of the local area and enhance and complement the surroundings. South Oxfordshire's Landscape Officer concluded that the Hif1 scheme would conflict with these policies. Jane Ash, giving landscape evidence on behalf of the county, also concluded that this would be the case. Her evidence was that after 15 years, the Hif1 scheme would have a residual moderate adverse impact on the landscape character of the site itself, and residual moderate or large adverse effects on visual amenity on 11 out of 48 representative viewpoints. Specific concerns were raised by the landscape officer about the road design around the Culham Science Centre roundabout, although semi-mature trees could have an immediate effect in softening the appearance of the scheme in this location. There are a range of planning conditions that can be used to control landscaping and mitigate the visual impact of the scheme. Concerns were also raised about the loss of trees. It's clear that there will be a significant amount of tree loss initially, but the county's arboricultural impact assessment confirms that after 10 years, the level of canopy cover within the site will be between 13% and 17%, compared with the baseline level of 14%. Ms Bauman's assessment is that any road scheme proposed in the rural area, i.e. north of the River Thames, would have an adverse effect on character and appearance, and that this is something that was expected through the inclusion of Hif1 in the local plan. The policy conflict is inevitable. It's something that needs to be weighed against the benefits of the scheme in the overall planning balance. And so far as biodiversity is concerned, there is a draft condition which would secure the 10% biodiversity net gain, which would meet the requirements of policy ENV3. Heritage. There's a suite of local plan policies relating to the protection of heritage assets. Policies ENV 6, 7, 8 and 10 are relevant, as well as policy COL 6 of the Culham Neighbourhood Plan. Overall, they reflect the requirements of national policy on this issue. The framework requires great weight to be given to the conservation of designated heritage assets. Any harm to significance requires clear and convincing justification. Where a proposal would lead to less than substantial harm to significance, this should be weighed against the public benefits of the proposal. The expert heritage evidence presented to the inquiry by Gillian Scott concludes that there would be less than substantial harm to the Grade 2 listed Fulham Moor farmhouse and to the Newnham Courtney conservation area. There would also be low-level, less than substantial harm to Clifton Hampton conservation area, but only until the landscaping matures. South Oxfordshire's Conservation Officer took a slightly different view. In the last set of comments dated 20th of June 2023, she concluded that there would be less than substantial harm to the significance of Fulham Moor farmhouse and the Clifton Hampton conservation area during construction. However, her view was that as long as the acoustic and landscape mitigation could be achieved, there would be a beneficial effect in the long term. This is because the Hif1 scheme would take vehicles and lighting further away from the heritage assets. The Rule 6 objectors have not sought to argue that the Hif1 scheme should be refused on the basis of its impacts on heritage assets. In fact, the only person who discussed the issue during the inquiry was Professor Ayres. His position was predicated on assumptions about the level of traffic increase through Newnham Courtney, which OCC have disputed. Any less than substantial harm needs to be weighed against the public benefits of the scheme. Ms Bauman was in no doubt that the considerable benefits of the Hif1 scheme outweigh such harm. The heritage balance falls to be struck decisively in favour of the scheme. Other matters. The county has presented expert evidence on a large number of technical topics, including transport modelling, highways engineering, noise and air quality. South Oxfordshire has not sought to call evidence or cross-examine on these issues and does not make any detailed submissions on them. However, the Council has considered the written evidence submitted on these topics and has listened carefully to the oral evidence. South Oxfordshire's view is that the county's evidence on these issues has not been undermined in any material way by evidence or questioning from the Rule 6 objectors and should be accepted. Consequences of refusing permission for Hif1. There are 4 key implications if Hif1 does not go ahead. First, based on the evidence about the existing highway network and the releasing development strategy, it's probable that the county will return to a position of objecting to new traffic generating development. If South Oxfordshire determines applications in accordance with that position, it would effectively amount to a moratorium on growth in the Didcot town area, precisely where the SOLP seeks to focus growth. As Mr Butler rightly pointed out, it would of course be possible for both districts to continue permitting housing growth, notwithstanding objections from the county, if it would judge that the benefits of housing outweigh the conflict with transport policies. The consequences of that approach have been clearly explained in the county's transport evidence. Second, there will be significant implications for South Oxfordshire's housing land supply position. South Oxfordshire does not currently have a 5-year supply. Ms Baumann explained that the Council has had previous experience of working in this situation, and the result has been a significant amount of speculative development, focused on those towns and villages within the relatively unconstrained area between the Greenbelt and the Chilterns National Landscape. Although the large strategic sites which depend on Hif1 are not presently relied on within the 5-year supply, they are expected to contribute to the land supply position in future years. If those developments can no longer come forward, that important contribution will be lost. This will simply prolong the period during which a 5-year supply cannot be demonstrated with predictable results. Furthermore, speculative development at towns and villages is inherently less sustainable than delivery of new sustainable settlements in the Science Vale, which are well located in terms of jobs and transport. A dispersed pattern of development results in greater reliance on the private car, together with the associated congestion and emissions. Third, the emerging joint plan proposes to continue with the strategy of focusing growth on Didcot and the Science Vale and carries forward the important Hif1 dependent strategic allocations, supported by the delivery of Hif1. If permission is refused, that preferred spatial strategy will not be deliverable, and the districts will have to reconsider the strategy of the emerging plan. This is bound to delay the production of the plan. Finally, Ms Baumann observed that there may be implications for public confidence in the planning system if the infrastructure which is needed to support planned growth cannot be delivered, particularly bearing in mind that some of the growth which it was supposed to mitigate has already been delivered. Overall planning balance. Whether any local plan policies may be out of date. Development plan policies which are inconsistent with the framework may be regarded as out of date, and this may in turn point towards a reduction in weight to be given to such policies and or to any conflict with them. Only Mr Tamplin sought to identify an inconsistency between the local plan and the framework. His argument was that any plan which supports road building is inconsistent with paragraph 115 of the framework, which provides that development should only be prevented or refused on highways grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network would be severe. It was said that the inconsistency arose due to the climate emergency. Mr Tamplin did not identify which specific policies were said to be inconsistent with the framework, whereas paragraph 226 makes clear that inconsistency is judged by reference to policies and not the plan as a whole. Presumably the policies in question would be those which provide support for the delivery of Hif1, most obviously Trans 1B and Trans 3. Mr Tamplin's argument was flawed for several reasons. Paragraph 115 is found under the heading Considering Development Proposals, thus it applies to the determination of planning applications rather than guiding the content of strategic policies. In any event, the residual cumulative impacts referred to in paragraph 115 do not relate to climate change. Rather, as the policy states, the concern is with impacts on the road network. This largely relates to the performance of the road network and its ability to accommodate forecast traffic. The topic of climate change is addressed separately by the framework in Chapter 14. The wording currently found in paragraph 115 has remained unchanged, albeit with different paragraph numbering, since the wholesale revision of the framework in 2018. The local plan was examined in 2020 and found sound and therefore consistent with national policy. The issue of climate change was expressly considered by the examining inspector in the context of the level of housing growth which was being planned for and which, as discussed, depends on infrastructure, including Hif1. Furthermore, a lengthy appendix of the local plan outlines the ways in which the policies and proposals within the plan seek to address climate change in accordance with the legislative framework as at June 2020. No other areas of inconsistency have been identified by any witness. The local plan is recently adopted and all of the policies which are of importance for the determination of this application are up to date. It follows that each policy is deserving of full weight. Whether Hif1 is in accordance with the development plan. The Rule 6 objectors have not mounted any real argument that the Hif1 scheme conflicts with the development plan. Mr Tamplin accepted that Hif1 is in accordance with the local plan, and Mr Turnbull did not identify any conflict with its policies. The Hif1 scheme is fundamental to the spatial strategy, and thus it's no surprise that the scheme receives strong in-principle support from the development plan. There's some low-level, less than substantial harm to heritage assets which must be given great weight, but the substantial public benefits outweigh that harm so that local and national heritage policies are complied with. The Hif1 scheme is, in our view, inappropriate development in the Greenbelt, and that definitional harm must be given substantial weight, but the benefits of the scheme clearly outweigh it and any other harm, and very special circumstances exist. Thus, there is compliance with local and national policy on the Greenbelt. There's no conflict with any of the policies in the Culham Neighbourhood Plan. There's some conflict with policies ENV1 and DES2 due to the landscape and visual impact of the Hif1 scheme, but that is inevitable for a scheme of this nature and is reasonably localised. Ms Bauman's assessment is that the Hif1 scheme is in accordance with the development plan taken as a whole, and that there are no material considerations which indicate permission should be refused. Conclusions. For all of the above reasons, South Oxfordshire contends that there is a very strong case for granting planning permission to allow this essential infrastructure to be delivered so that it can perform its role in unlocking important housing and employment development and delivering the spatial strategy. South Oxfordshire therefore respectfully invites you to recommend that the application is granted. Thank you.
Mr Flanagan, just before you do, the condition from May's properties, have you had a chance to look at that?
I have, thank you. So I could just briefly say what I've got to say on that. So the May's property have proposed, I think, a revision to the condition such that it doesn't preclude all development, it precludes construction work on the southwestern arm of the new Backhill roundabout. Mm-hmm. So our response to that is that what Mr Humphrey said on Friday afternoon, that remains our position overall. To explain that in a bit more detail, the condition as revised still prevents the Hif1 scheme, certainly a portion of it, coming forward on the basis of the emerging Mays scheme, for which an application was only made in February of this year, for which no significant consideration has been given, as Mr Butler, the case officer, helpfully explained on Friday, and certainly there's no planning permission yet, so it's all still emerging, still up in the air. The condition is now more limited in scope, but that southwestern arm of the Backhill roundabout that the Mays condition refers to, it doesn't just provide an access to the Mays site, it provides access to at least two other significant development sites. They are what's called Minscombe proposed development site.
So can you spell that, please?
Minscombe, Minscombe. Okay. And if it's useful, it is in fact shown on the General Arrangement Plan D01.
Can I just give me a moment? It's Plan 1.
Yes, sheet 1 of 19, yeah.
Right, thank you.
So there's the Minscombe site. There's also, you may have seen reference to it, it's not shown on the plan, but I can explain where it is. It's called MEPC, which is another development site, and it's actually within that dotted red line on the plan you're looking at, which says Maze. It's right to the western edge of it, just above the word footpath, for footpath 299, 10, 20. There's a triangle of land which is a separate development site. So there's those two sites which would be sterilised essentially, pending the condition being complied with. There's also, Mr. Wisdom referred to it, what's the Milton Heights Bridge, which is a separate proposal that, not part of the scheme, but is part of the county's plans, that the southwestern arm of the Backhill roundabout will, in due time, continue south, and then you'll get a linking bridge over the A34, which is a few hundred metres south of the southwestern arm. So again, that would be held up.
And is that a scheme that's been, I don't know if it needed approval, they don't, if it's a county scheme, is it?
It's a county scheme, it's being progressed. I'm not aware that it has the necessary...
Thank you.
In fairness, that doesn't have planning permission yet, but it is certainly still something that is being progressed.
And the purpose of that one is to access the Milton Heights residential scheme, or is it?
It is. So the Milton Heights, that's south of the A34, a housing development site, and it would provide connectivity more widely. For walking and cycling only.
I was just going to say that's my recollection.
Yes, your recollection's correct.
So Milton Heights is partly constructed, I think, isn't it? I think I've seen signs for it in the area.
It is partly constructed, and they've also reserved the land within the partly constructed site for the landing site of that bridge. So it's clearly planned to a reasonable extent. There's two final short points. There's a separate point that the condition appears to envisage simply a replacement plan being produced by way of condition. We have doubts about that. There doesn't appear to be any consideration given, certainly not expressly, to how that would work, because it would essentially amend the scheme in an admittedly small way, but you'd have to consider ES assessments and so forth. So it seems to be a further separate issue. So those are the continuing objections to that condition. Can I just then finally briefly say Mr. Mays' Mr. Roberts' email on behalf of Mays. He says that Mr. Humphreys on Friday suggested that the revised Mays scheme had come out of the blue, and Mr. Roberts takes issue with that and says actually it had been tabled or certainly mooted before. And just to confirm, we don't dispute that mention may have been made of it before February when it was submitted, but what had not been specified or made clear was that the new scheme, which has now been submitted for permission, had a revised access which was inconsistent with the Hif1 scheme. So the effect is that essentially Mays are proposing a scheme in February 2024 with an access which does not tie into Hif1, for which planning permission was applied for in September 2021. So nearly 3 years later. Those are my points on that.
Thank you.
Hand up my closing. So can I just say, you'll see that it's a substantial document, given the amount of evidence we've heard. It's 78 pages. I'm not proposing to read it all. I don't think there'll be time to do so. I hope that's acceptable. I'm not sure anyone would thank me if I did. I'm going to read parts of it and try and read the parts of it which summarise the overall position and keep to the sort of length that you've already heard from others this afternoon today. So,
Whenever you're...
starting from the top then, paragraph 1, these closing submissions on behalf of the County Council as applicant for planning permission for the Hif1 scheme will deal with each of your Madam in 14 main issues in turn, along with any additional issues that have arisen during the inquiry process, and in doing so will address the matters about which the Secretary of State particularly wishes to be informed. Before turning to those detailed issues, it is important to keep the overall picture in mind. There is a compelling need for this scheme. It will provide modern, fit-for-purpose transport infrastructure that is needed for the thousands of homes and jobs planned for the area to come forward. The scheme is a fundamental plank of the adopted development plans for the area and will enable their ambitions to be realised. Very significant benefits flow from this, meeting housing and employment need, enabling economic growth in an area which is vitally important to the local, regional and indeed national economy, and doing so in a way that will facilitate sustainable modes of travel. The scheme will have environmental benefits, particularly in taking existing and future traffic away from villages, small country roads and historic bridges, and improving residential amenity. The need and benefits of the scheme can only attract very significant weight. The adverse effects are, by contrast, limited in scope and number. It's inevitable that some such effects will arise when providing large-scale infrastructure such as the scheme, but the scheme has been sensitively designed to ensure that the effects are minimised and accompanied by appropriate mitigation so far as is necessary. Overall, the scheme is important, urgently needed, and should be allowed to come forward. So dealing with issue 1, which I will read in full. Issue 1, need and benefits of the scheme. Firstly, enabling housing and employment growth in the local plans. The need for the scheme derives most directly from the existing planned housing and employment growth in Science Vale, which straddles the boundaries of the Vale of White Horse District Council and South Oxfordshire District Council, including the 3 centres for science and technology at Harwell Campus, Culham Science Centre and Milton Park, and is supported by the larger settlements of Didcot, Grove and Wantage. Science Vale is recognised and defined in the South Oxfordshire Local Plan, Vale of White Horse Local Plan Parts 1 and 2, and OCC's Local Transport Connectivity Plan. It's an area of innovation-led economic growth that is home to a significant proportion of the region's scientific research and development and high technology businesses. It includes 2 enterprise zones, Science Vale UK and Didcot Growth Accelerator. It anchors the Oxfordshire Knowledge Spine, which is a key north-south corridor of expanding employment opportunities that cover Bicester, Oxford and Science Vale. The Part 1 Vale Plan describes it as an internationally significant location for innovation and science-based research and business. The inspector for the South Oxford Local Plan referred to the world-leading science and research centres at Harwell and Culham. In a letter to the Planning Inspectorate, Secretary of State for Energy Security Net Zero emphasises the global significance of the Culham Science Centre and the importance of the scheme in enabling it to grow. The significance of the Culham Science Centre and the role of the scheme in enabling its growth is further endorsed by the written and oral evidence to the inquiry of Professor Ian Chapman, CEO of UK AEA. It's worth emphasising that the Culham Science Centre, as an internationally important centre for nuclear fusion, has a key role in promoting a lower carbon future and combating climate change. The housing and employment growth planned in the development plans for the area, South Oxford Local Plan and Part 1 and 2 Vale plans, depends on the scheme. the scheme has been developed alongside those local plans. Modelling was undertaken through the various evaluation of transport impact studies produced between 2014 and 2020 for all 3 local plans, and assessed through the examination process for the plans. The ETIs showed all components of the scheme to be necessary to enable the development proposed in the local plans to go ahead by providing a fundamental part of the mitigation strategy required. The local plans plan for very considerable housing and employment growth in the Science Vale area. Evidence provided to the South Oxfordshire examination showed that the scheme would directly underpin at least 19,319 homes within South Oxfordshire and Vale of Whitehorse areas. If one considers housing growth more broadly in the area, both homes recently constructed and expected to up to and beyond 2035, the figure is 29,714. The Science Vale is expressly identified as a strategic focus for growth in all 3 local plans. The Part 1 plan explains that we are planning to focus most of our development within the South East Vale sub-area, around 75% of the proposed strategic growth. This is because the area is home to the largest of our employment sites and where the largest number of new jobs will be created. The South Oxfordshire plan likewise explains that it has a focus on delivering housing and employment at Science Vale. There are a number of very large individual allocations, 3,500 homes and a net increase of 7.3 hectares of employment land adjacent to Culham Science Centre, 1,700 homes and 5 hectares of employment land at Berensfield Garden Village, 2,030 homes at North 1 Didcot, 2587 at Great Western Park, 2550 at Valley Park, 800 at North West Valley Park. Policy provides that these large strategic allocations, comprising thousands of homes and significant amounts of employment floor space, are required to contribute to and are dependent upon the scheme. For such housing and economic growth to be sustainable, there is a clear need for the necessary infrastructure to be in place to support it. For this reason, policies in the local plans expressly support all 4 components of the scheme and safeguard land for them. Although the precise location of components of the scheme may differ to some extent from the safeguarded land, generally the scheme is in the broad location safeguarded. And in any event, policy makes clear that the policies map does not seek to show a precise alignment for the transport schemes, which will need to be informed by detailed design work carried out in consultation with Oxfordshire County Council and other relevant parties. All these policies were scrutinised and found sound by the inspectors examining the local plans. The inspectors expressly endorsed, firstly, the need for the scheme as mitigation for the development proposed, and secondly, the robustness of the transport studies, which assessed the mitigation package. They found the scheme to be integral to both local plans' spatial strategies. Indeed, it's difficult to overstate the importance of the scheme to the local plans. Without the scheme, the local plans would fail. The planned growth could not come forward due to the absence of the infrastructure required to support it and mitigate its impact. That is the evidence of South Oxfordshire and Vale of Whitehorse district councils themselves, who have considered this scheme important enough to apply for Rule 6 status at this inquiry, to be represented and call witnesses. The leader of South Oxfordshire, Councillor David Raine, has attended and explained his council's view that the scheme is a fundamental part of our local plan, and that without it, the local plan would fail because so many housing sites, planned and existing, need this road to make them viable settlements. Both councils have made clear that they strongly support the scheme. South Oxfordshire put it in particularly stark terms, quote, "The refusal of planning permission for Hif1 would be catastrophic for the district." That is not language that you often hear at a planning inquiry from a local authority. Objections to the scheme on the basis that it's not needed or that there are alternative solutions must be recognised for what they are, objections to the local plans. The need for the scheme has been established through the local plans and they contain policies supporting the scheme. Such policy support has the force of statutory presumption in section 38(6) of the 2004 Act. It is simply too late and the wrong forum to raise such objections to the scheme. The local plans are up to date. The South Oxfordshire plan was adopted December 2020, less than 5 years ago, such that the legislative requirement for review has not yet arisen. The Part 1 Vale plan was adopted December 2016, and when reviewed in 2021 was found to continue to provide a suitable framework for development in the district that is in overall conformity with government policy. Part 2 Vale Plan was adopted in October 2019, such that it's less than 5 years old. The suggestion by some objectors that the local plans are out of date is wholly unconvincing. No objector could point to any relevant difference between the latest December 2023 version of the framework and the previous iterations of the framework against which the local plans were found sound. Mr Tamplin suggested that the local plans were inconsistent with Para 115 of the 2023 framework, but that deals with refusal for highway schemes on the basis that there would be an unacceptable impact on highway safety, or if the residual cumulative impacts on the road network would be severe, and there is no evidence whatsoever that the scheme would cause such impacts. Indeed, the scheme would prevent such impacts which would otherwise arise. Mr Turnbull alleged that policy CP17 regarding strategic highway improvements in the Part 1 Vale Plan was inconsistent with Para 116 of the framework, particularly the provision in Subpara A for giving priority to pedestrian and cycle movements. But the scheme plainly does make significant and high-quality provision for pedestrian and cycle movements, and in any event, the scheme is part of a wider strategy in the local plans and the LTCP that prioritises walking and cycling. The only other point was Mr Turnbull's observation that policy CP17 in the Vale Part 1 plan refers to Local Transport Plan 4, which has not been superseded by the LTCP. But as is clear from the LTCP, the policy support for the scheme in LTP4 has been carried forward into the LTCP. And I refer to the section on LTP4 review and Appendix 1, the Science Vale Area Strategy, which supports the continued delivery of all 4 components of the scheme. The reliance by some objectors on the emerging joint local plan goes nowhere. Given only an issues consultation has been produced, it can attract at most very limited weight, and even if it did attract greater weight, it supports and safeguards all 4 components of the scheme. Next, additional key issues which the scheme will address. Paragraph 15. In addition to enabling delivery of the planned development, the need for and benefits of the scheme manifest themselves in a number of further ways. As explained by Mr Wisdom, the scheme will address 5 key issues, with one being the delivery of housing and employment growth, which I've already discussed, and the other 4 being, first, the poor existing highway network performance, secondly, under provision of active travel in the area, thirdly, improvements in public transport, fourthly, need for adequate network resilience and safety. With respect to the first issue, poor existing highway network performance, Didcot and the wider Science Vale area has seen considerable growth in housing and employment over the past 30 years. This has led to significant traffic growth, both within the town and related to commuting across the wider area. Junction capacity assessments using 2020 base traffic flows show that a number of junctions are operating over capacity in either or both the 2020 morning and evening peak hours. And in particular, I refer to Clifton Hampden signalised junction is significantly over capacity, and practical reserve capacity is minus 240% or so, subject to significant queuing. And secondly, B, the Tollgate Abingdon Road junctions, including at the Cullen Bridges, see very significant queues, including queues of up to almost 1.2 kilometres in length in the AM peak period. The extent of these highway issues has resulted in proposals for single dwellings being refused planning permission on highway grounds, with the refusals being upheld at appeal. OCC has subsequently adopted a development release strategy which allows the delivery of housing subject to mitigating measures, but that strategy is expressly predicated on the scheme coming forward. And as explained by Mr Wisdom, if the Hif1 scheme were not to proceed, OCC would need to remove the development release strategy and reconsider its approach to development in the area. In cross-examination of Ms Curry, Mr Woolley sought to downplay the extent of the current congestion. Ms Curry agreed that there was not gridlock currently, but did not otherwise accept Mr Woolley's suggestion. She was also at pains to point out that the scheme is needed to alleviate the traffic impacts that would otherwise arise by 2034 with the planned growth. While there might not be gridlock today, there would be in 2034 unless the scheme comes forward. And this is demonstrated by the modelling results for 2034 without the scheme, which shows severe congestion at many more junctions across the scheme, with queues of over 600 vehicles long. Indeed, the model, when run at full demand in 2034 without the scheme, showed gridlock, and therefore to get to the model to work at all, it had to be run at 70% of demand, with the results then factored up to full demand. Objectors have suggested that the scheme is only a short-term solution in purported reliance on the graphs from the transport assessment, which allow comparison of average speed and journey times between 2024 without the scheme and 2034 with the scheme. And they also note, the objectors, that some of the development sites in the local plans may not be fully built out by 2034, such that further growth may come forward after 2034. And that misrepresents the evidence. The graphs show that with the scheme in 2034, average journey times and speeds are broadly similar to 2024 without the scheme. That means that despite all the planned growth, the scheme allows the road network to function in 2034, in addition to delivering significant levels of high-quality cycling and walking infrastructure, and thereby succeeds in its objective of allowing this planned growth to come forward. In addition, whilst average times and speeds across the network will be broadly similar in 2024 without the scheme and 2034 with the scheme, the detailed junction assessments show that acute current issues at particular junctions, especially around the river crossings, are significantly alleviated. The graphs show that without the scheme, by 2034, average speeds and journey times will be very significantly worse, evidencing the gridlock that Ms Curry said would occur. That is what the scheme avoids, which is a major and long-term benefit, nor is there any evidence before the inquiry that after 2034 the position will deteriorate. On top of the clear evidence from the modelling is the powerful evidence from those who actually have to use this highway network today. The inquiry has heard extensive evidence of the real-world problems this network is causing to people's lives today, even before the impact of thousands of new homes is added to the network. For example, Mr. Alcantara, who's responsible for the Cullen Bus Club, which transports 500 pupils daily to 6 schools, explained how on a normal day the queue's up to 30 minutes at the Cullen bridges, and in the event of a road closure elsewhere, the delays can grow to an hour. And when the bridge is closed due to flooding, the diversion through Abingdon can take more than 2 hours. The result is hundreds of children late for school, missing hours of education, or having to get up earlier and earlier in order to spend time sitting in traffic. Sue Skane, Deputy Chair of Didcot First and Chair of Didcot Volunteer Drivers, explained how the volunteer drivers taking people to medical appointments have to suffer delays, unreliable journey times, and very significant diversions. Ms Skane's statement was supported by evidence to similar effect from David Pryor, the Chair of Didcot First. Councillor Sally Powolotsky explained the effect of the current situation on her local residents in the Hendrids and Harwell division, for which she's the county councillor, that the impact on daily lives is exhausting. The alternatives to driving aren't viable in terms of efficiency or cost. Simon Peacock, Chair of Western Valley Parish Council, made comments to similar effect, commenting that the road infrastructure is woeful at the moment. There's also strong support from UK AEA, whose presence at this inquiry as a Rule 6 party is indicative of the importance of the scheme to them, and various other commercial parties and private individuals. Generally, it's clear from the representations to the inquiry that there is firm and widespread support for the scheme. Not everyone agrees, but there's no evidence that the views of poets and the Neighbouring Parish Council's Joint Committee put forward to this inquiry are representative of the vast majority of those who live and work in the area. In respect of the second issue, under provision of active travel, there's a paucity of active travel provision across Science Vale. In Didcot and the wider Science Vale area, the active travel network is fragmented and limited. For example, there's currently no direct cycle route between Didcot and Cullen Science Centre, but only convoluted options including on narrow and congested roads which are not conducive to cycling, even for the most experienced cyclists. Such cycle paths as exist are often narrow and uninviting, such as that along the A4130, with at most a thin buffer between cyclists and often heavy traffic thundering along the carriageway. In respect of the third issue, need for improvement in public transport, due to the severance created by the River Thames to the north and the Great Western Main Line to the south, coupled with the historic road network and frequent traffic congestion, bus journey time reliability suffers in the area, and that in turn impacts attractiveness and viability. As such, there are currently only limited north-south services operating across the river to the north of Didcot. The existing transport network in and around Didcot, and with the expected levels of housing and employment growth, will not operate efficiently for any mode of transport without intervention. The representation from the Oxford Bus Company provides particularly powerful evidence of this. Their statement explains how the current congestion and inadequate infrastructure is a serious barrier to attractive, reliable bus services, and that, quote, the delivery of the proposals is crucial to directly supporting the efficient and reliable operation of existing services. There is great irony in the position of objectors to the scheme who promote buses as an alternative to the scheme, but actually jeopardise even the existing services if the scheme was to be refused, as they suggest. The company concludes that without the timely delivery of the proposals, the level and quality of bus service, both current and in the future, would be placed in very serious peril. In respect of the fourth issue, the need for adequate network resilience and safety, the existing bridges at Culham and Clifton Hampton are listed 19th century structures in flood zone 3, and in 2021 and 2024 had to close due to flooding for almost a week, exacerbating already serious congestion issues and leaving some villages temporarily without a bus service at all. The scheme is needed to provide resilience in this respect. The scheme will address all these issues in an integrated and effective way. It will avoid severe transport impacts which would otherwise lead to refusal of housing and employment growth, MPF Para 115. It will alleviate congestion on the highway network and enable modal shift across Science Vale, including by facilitating the enhancement of bus services and encouraging walking and cycling. It will improve accessibility across the River Thames and the Great Western Main Line, increase resilience on the network and provide direct routes linking up the housing and employment sites, rather than forcing traffic to adopt circuitous routes and cut through villages. The scheme will in future take traffic out of villages and settlements, including but not limited to Appleford, Clifton, Hampton and Sutton Courtenay. So in Sutton Courtenay, the traffic flows with the scheme are substantially reduced from the no scheme position. The links through the village see reductions of between 18 and 49%. For example, at the southern end of the village, the flow in 2034 is reduced from around 14,000 vehicles per day without the scheme to 7,000 vehicles per day with the scheme. That is taking 7,000 vehicles daily out of the village. Over the Culham bridges, the figures are even more dramatic, at 70% in 2034 with the scheme, from 10,000 vehicles per day to 3,000 vehicles per day, and a similar percentage in 2024. In Appleford, the daily traffic flow reduces by 64% with the scheme in place in 2034, from 8,500 vehicles without the scheme to 3,000 vehicles with the scheme, and a similar percentage in 2024. In Clifton Hampton, the daily traffic flow reductions are between 77 and 83% with the scheme in place in 2034, reducing around, for example, from 12,700 vehicles per day to 2,500 vehicles per day near the A415 Oxford Road junction, and again similar reductions in 2024. As I'll set out further below, the scheme's environmental effects are positive, reducing traffic noise in settlements and the air quality and climate change effects of congestion. The scheme offers vastly improved opportunities for active travel and public transport. The assumption underpinning a number of objections that the scheme is essentially a road-only scheme designed for the private car bears no relation to what is actually proposed and what it will achieve. In particular, the road capacity provided by the scheme will enhance bus journey time reliability and enable new bus service links, as evidenced in the representation from the Oxford Bus Company. There are significant active travel benefits in the provision of approximately 20 kilometres of new and or improved off-road carriageway, cycling and pedestrian infrastructure. As explained by county witnesses, it will be attractive and spacious with buffers between the cycleways, footways and vehicular carriageways, convenient crossing points prioritised for non-motorised users wherever possible, and it will be well lit and safe. The scheme also enables wider connectivity to footpaths, bridleways and other cycle networks. Indeed, the Didcot Local Cycling and Walking Infrastructure Plan states that Hif1 is the cornerstone of a wider future active travel network that addresses the existing severe severance to walking and cycling created by road, rail and river in the Didcot and surrounding areas. It is the central puzzle piece that unlocks a predominantly off-road walking and cycling route from Oxford to Harwell Science and Innovation Campus and further afield in both directions via Kennington, Radley, Culham Science Centre, multiple rail stations and Didcot. The scheme does not aim to provide unlimited highway capacity for cars and has not been modelled and designed on this basis. The scheme is fundamental to delivering the aims of Didcot Garden Town by reducing the impact of existing and forecast traffic within the area using a decide and provide methodology. The scheme will help to make walking and cycling more attractive and to realise the network of improvements identified in the adopted Didcot LC Whip. Further, next heading, further policy support for the need and benefits of the scheme. Paragraph 30. The need for and benefits of the scheme also gain weight by their recognition in other tiers of policy beyond the local plans. I'll deal with the LTCP under issue 3 below, but the county say that there is full compliance with the LTCP. The scheme is embedded in the Didcot Garden Town Delivery Plan, which includes all 4 components of the scheme. It specifically supports the Didcot Science Bridge as a mechanism for reducing traffic travelling through the centre of Didcot by redirecting as much traffic as possible around the town's northern periphery and reducing severance caused by the railway line. It promotes the enhanced walking and cycling provision along the A4130 between Milton Interchange and Didcot that will be delivered under the scheme. Objectors have referred to the Garden Line proposal in the delivery plan, which is a proposed cycle and pedestrian route between Harwell and Culham via Didcot. The scheme and that proposal are not mutually exclusive, however, the delivery plan envisages both potentially coming forward. Also, it should be recognised that by the scheme incorporating segregated cycling and walking provision alongside the new carriageway, including across a new bridge over the Thames, the scheme is to a very significant extent realising this objective of the delivery plan of providing a new and high-quality cycling and walking route linking Didcot and Culham. It should also be noted that the Garden Line is no longer included on the list of revised Didcot Garden Town Delivery Plan Projects 2022 submitted to the inquiry by Vale. Finally, the need for and benefits of the scheme are recognised in national policy, which is strongly and directly supportive of the scheme. The scheme, by being rooted in development plan and transport plan policy, is, quote, genuinely plan-led, para 15 of the framework. In accordance with para 11 of the framework, the scheme enables sustainable growth by aligning growth and infrastructure. Of very direct relevance to the scheme is para 74 of the framework. It encourages larger scale housing, such as seen in the large allocations in the South Oxfordshire and Vale local plans, providing that the supply of large numbers of new houses can best be achieved through planning for larger scale development, such as new settlements or significant extensions to existing villages and towns. This comes with the caveat, provided they are supported by the necessary infrastructure and facilities, including a genuine choice of transport modes. And that is precisely the function of the scheme. The scheme, by unlocking economic growth and employment sites, is also directly aligned with paras 85 and 86 of the framework, which seek to create the conditions in which businesses can invest, expand and adapt, including by addressing potential barriers to investment, such as inadequate infrastructure. So, in conclusion on issue 1, the evidence before this inquiry is that the need and benefits are entirely compelling and worthy of very substantial weight. That evidence has not been seriously challenged. Poets and the Joint Committee and certain other objectors raised specific points of opposition in respect of alternatives in the modelling, which I'll deal with below, but there has been no coherent and evidence case put to the inquiry gainsaying the need and benefits case. Certainly, the county invites you, Madam, to conclude that the need and benefits as advanced by the county, the district and other supporters are wholly made out. Then turning to issue 2 on transport modelling, and I'm going to be more selective from now on. So paragraph 35, the scheme has clearly shown the modelling approach to be robust. It has been developed over a number of years and has been carried out in 3 stages, each building on previous work and ensuring that the best available traffic data has been used in the decision-making process. First, high-level strategic modelling was undertaken using the Oxfordshire Strategic Model, a model which considers Oxfordshire as a whole. Ms Curry explained that the OSM is fully compliant with DfT's Transport Appraisal Guidance tag and has passed the appropriate calibration and validation criteria. Secondly, detailed micro-simulation modelling of the entire Didcot area, including the area covered by the scheme, was carried out using the Didcot Paramix micro-simulation model. This model has likewise been calibrated and validated in accordance with tag and other guidance, and validation data confirms it has a robust base for use in assessing developments and infrastructure proposals. Thirdly, detailed assessment of specific junctions was undertaken using standalone junction models, utilising industry standard software and relying on the output flows from the validated Paramix model. The modelling has in turn formed the basis for the comprehensive transport assessment supporting the scheme, and the robustness of the modelling has been informed by the expert evidence of Ms Curry to that effect, a highly experienced expert in transport modelling, the calibration and validation process I've set out, its compliance with tag and other guidance, the fact that the traffic flow information from OSM was used as the basis for the evaluation of traffic impacts arising from the development proposed in the 3 local plans, and the inspectors relied on the modelling as a sound basis to understand the traffic impacts. And the review of the modelling by the Transport Development Control Team of OCC, the Highway Authority scrutinised the modelling as part of the planning application process, including by taking advice from external modelling consultants, and confirmed that they were satisfied with the modelling. And finally, the review by Origin Transport Consultants, who rejected concerns raised about the extent of the modelling, in particular in not including junction modelling for the Golden Balls roundabout or for Abingdon. So that's a summary of the modelling, and I'm now going to skip forward a few paragraphs to paragraph 50. So if I could go to page 23, please, paragraph 50, where I say, more generally, it is inevitable that there will be some uncertainty with projections. That's not a substantive argument against the scheme. In light of the powerful evidence as to the urgent need for the scheme, any uncertainty inherent in the fact that traffic modelling involves projections does nothing to undermine the case for the scheme. Professor Goodwin referred to the potential for future modal shift and behaviour change, and Mr Turnbull thought that greater modal shift should be modelled. But Professor Goodwin himself described the 20% reduction for new development that has been built into the modelling as ambitious and close to the limits of what might be achievable. The argument that the scheme should not be progressed because there cannot be 100% certainty as to the projections, or in the hope of some unanticipated and wholly improbable further modal shift materialising, is, with respect, irresponsible. It is playing dice with people's future, their ability to get to work and school, to get to hospital appointments, to do all the things which they should be able to take for granted. Finally, it should not be forgotten that the network for car, bus and non-motorised users is not fit for purpose currently, even leaving aside the impact of the substantial housing and employment growth that is coming forward. It is of course right to consider the robustness of the modelling, but the question of precisely how much worse the problems will get in the future should not obscure the fact that the deficiencies are plain to see on the ground today. So in conclusion on issue 2, in summary, the traffic modelling provides an entirely robust basis to assess the need for and effects of the scheme in traffic and transport terms. It incorporates 3 tiers of modelling and has been developed and found to be sound over the course of a decade, in particular through the local plans that relied on it and in the course of this application, through review and scrutiny by the county's Transport Development Control team. The inquiry has the largely unchallenged expert evidence from Ms Curry, which has comprehensively shown the issues raised by objectors, including the suggestion of wider impacts to the west and the east, induced traffic and uncertainty, to be without substance and to provide no proper basis to go behind the model outputs. Then turn to issue 3, which is whether the proposal would make acceptable provision for sustainable travel, including walking and cycling, and accord with the local transport and connectivity plan. And again, I don't read all of this section. You have it there. I deal with the LTCP. I deal with walking and cycling. So I go straight to paragraph 65 at the top of page 29. Paragraph 65, I say, accordingly, the scheme fully complies with and gains strong policy support from the LTCP. It is a key part of the LTCP integrated transport strategy for the Science Vale. It complies with specific policies, including on taking a decide and provide approach. It makes extensive and high quality provision for active travel, walking and cycling, and enables improved public transport through enhancement to bus journey reliability and potential additional services. Then turn to issue 4, consideration of alternatives. The first subheading under alternatives is the approach, which I will read, paragraph 66. It's important to approach the issue of consideration of alternatives on the correct basis. This inquiry is concerned with the scheme for which planning permission is being sought, not some other alternative project. The question of whether to grant planning permission must be determined by reference to the planning merits of the scheme. Case law indicates that the consideration of alternative sites or schemes will only be relevant to a planning application in exceptional circumstances. In the present case, the county say that no such circumstances exist. The scheme has express and strong support in the development plans for the area and in the LTCP. The broad route is safeguarded in the development plans. There is compliance with the development plan overall, and any areas of non-compliance are limited. The benefits are wide-ranging and compelling. Any harms are limited in number and extent and are inevitable for a project of this sort. Taken together, all that weighs strongly against any suggestion that exceptional circumstances exist, making alternatives relevant. I then deal with alternatives to the scheme. I deal with under the next heading, under the optioneering process at some length. It's been set out in the evidence. I then, at paragraph 72 on page 33, have a subheading for alternatives at Appleford. It's obviously the route alignment concerns by the Joint Committee and Parish Council and Poets. And then, so you have that there, I don't read that out. I then go to paragraph 76 at the bottom of page 34. In conclusion, on issue 4 alternatives, I say in conclusion, the scheme has been the subject of a very extensive and robust optioneering process, which has shown that there are no feasible and realistic alternatives to the scheme. That includes all of those advanced by objectors, such as public transport, bus and rail, and active travel options. The existence of alternatives is not generally a basis to object to the grant of planning permission, but in any event, the work done has shown that there are none here. There are no alternatives here. Optioneering at a more detailed level, such as the alignment around Appleford, has likewise shown that what is proposed achieves the scheme objectives and has been carefully designed to minimise impacts. The next heading is issue 4A. Madam, this is an issue of our creation, not on your list, but as I say at paragraph 77, it's about the adequacy of the environmental statement, and we deal with it here as it's connected to the objector's case in respect of traffic modelling, that's issue 2, and alternatives in issue 4. And if I read paragraph 79, in summary on the first issue, that's the first issue raised by objectors, the geographic scope of assessment was defined based on likely significant effects. The areas referred to by objectors were properly considered to be outside those where significant effects were likely. As I've discussed under issue 2 in respect of traffic modelling, the scheme will not materially increase traffic flows in Abingdon or at the Golden Balls roundabout, or to the north at Newnham Courtney, or to the west beyond the Milton interchange. The objectors have produced no contrary evidence that traffic flows in these locations will be changed, such that their point is pure assertion. The bespoke methodologies in respect of specific environmental disciplines were all based on the potential for significant environmental effects, and the assessments were tailored accordingly, including in respect of the issues particularly raised by objectors such as transport, air quality, noise and vibration. Accordingly, insofar as the environmental statement does not present detailed assessments of the scheme's effects upon settlements located further west and east of the scheme, that is for the entirely proper reason that these areas have been considered as part of the EIA process early on, and it has been shown that significant environmental effects would be avoided in these locations. The methodology and study area are set out in the transport assessment and in Chapter 16 of the ES were discussed and agreed with the local highway authority, national highways during pre-application scoping. Where the LPA considered that further information was required, it was requested and supplied via the 2 Regulation 25 requests. On the second issue, it's the second issue raised by objectors regarding the environmental statement, the Town and Country Planning Environmental Impact Assessment Regulations requires the environmental statement to include, quote, a description of the reasonable alternatives studied by the developer which are relevant to the proposed development and its specific characteristics, and an indication of the main reasons for the option chosen, taking into account the effects of the development on the environment. The ES plainly complies with that obligation, in particular through Chapter 3, Assessment of Alternatives. And I then skip to the conclusion on issue 4A, which is at paragraph 85. I say, accordingly, the ES is entirely sufficient and legally compliant in scope and content, including in respect of the 2 issues of alternatives and geographic extent raised by objectors. Contrary to the suggestion by poets, there is no need for you, Madam, or the Inspector, for you, Madam, or the Secretary of State to issue a further request under Regulation 25 of the EIA regulations. I then go back to your list of issues, and issue 5 is the effect of the proposal on the character and appearance of the surrounding landscape, including any loss of trees and or hedges. And under this heading, I deal with those matters, landscape and visual matters, at some length, dealing with the evidence from Miss Ash, Mr. James in particular, and I go, if I please take that as read and go to paragraph 101, which I do wish to highlight. Paragraph 101, I say appropriate conditions are agreed to ensure mitigation planting is properly planned and maintained over the long term and trees protected. The applicant is undertaking to provide a £50,000 landscaping enhancements fund for the local community to use more widely, but the applicant makes clear that it considers that you, Madam, and the Secretary of State should not place any weight on this matter in determining the application. So just to interpose, that is what I said earlier about not placing weight on it, that is, we put it in writing there. Then paragraph 103, I turn to that, conclusion on issue 5. Overall, there is some conflict with the development plan policies which provide for the protection of the environment, in particular ENV1 of the South Oxfordshire Plan and CP44 of the Part 1 Vale Plan. As concluded by Mr. Greep, however, that scale of conflict is relatively modest, and as I'll set out below, it plainly does not preclude compliance with the development plan overall, and the adverse landscape and visual effects are significantly outweighed by the benefits of the scheme. Issue 6 then, whether the proposal would be acceptable in terms of impacts on noise, and don't read all this either. I deal with paragraph 106, construction impacts, paragraph 107, operation impacts, some detail, and then at paragraph 112, bottom of page 48, and over the page onto 49, I then deal with points raised by objectors, which I've highlighted in bold, impacts on Appleford, noise important area, top of page 50, Newnham Courtney, Appleford Sidings Bridge, this is all the bold text. Dr. Jones's concerns about being downwind, HGV use and so forth. So I go then to paragraph 113 to conclude on noise. Paragraph 113, I say that the points raised by objectors do not detract from the clear conclusion that there is compliance with noise policy in this case, and the fact that, notwithstanding some recognised adverse noise effects, overall the scheme is significantly positive in taking traffic away from residential receptors and significantly reducing the numbers of properties exposed to high levels of traffic noise. Issue 7 is whether the proposal would be acceptable in terms of air quality. I don't read this, but I follow a similar structure. You'll see from the paragraph 115, I deal with construction air quality effects. Paragraph 116, in bold, operational air quality effects. And then in paragraph 118, I likewise, as with noise, here with air quality, go through the issues raised by objectors in particular. So in bold, impacts in Appleford, bottom of page 53. Page 54, Appleford Sidings Bridge, points about the gradient, about it being downwind. Over the page at page 55, I discuss PM 2.5, concerns raised, and provide chapter and verse on that. I also deal with Abingdon and Newnham Courtney at the bottom of page 55 in bold. And then that takes me to paragraph 119 to conclude again on issue 7. I say that overall, the position in respect of air quality is again a positive one. Air quality is generally good in the area. Air pollutants are well below objective values. For example, the highest predicted annual mean NO2 concentration at an existing property is 24.5 micrograms per metre cubed, which is well below the 40 microgram per metre cubed annual mean air quality objective value. No exceedances are predicted. The scheme results in some reductions and some increases, but given the existing and future baseline, none of the effects will be significant in air quality terms. And then issue 7A next, again, that's an issue of our creation health, but it was raised, so we've included it. I'll read paragraph 120. Although not specifically identified in, Madam, your list of issues, the proposed reasons for refusal mention the absence of a health impact assessment, which objectors have also raised as an issue. Impacts on health have been properly assessed and reported, as now agreed by the local planning authority. Dr. Jones was incorrect, we say, in her evidence to assert otherwise. As explained by Mr. Maddox, prior to the adoption of the LTCP in 2022, after submission of the application in 2021, there was no requirement for a separate HIA to be undertaken for major infrastructure schemes. However, the relevant chapters in the environmental statement, in particular on population and human health, air quality, landscape visual impact, and noise and vibration, provide all the necessary information for an assessment of the impacts of the scheme on health and well-being. Indeed, for schemes above the EIA threshold, the environmental statement can plainly serve the function of an HIA, unlike schemes below the threshold, where a standalone HIA will be needed in the absence of an ES, health, noise, air quality chapter, etc. Guidance from Public Health England explains that it can be appropriate to integrate HIA within EIA. The adequacy of the environmental statement in respect of health has been specifically agreed by the public health officers. A rapid health impact assessment review checklist was also produced in September 2023 to provide a detailed route map showing how health matters have been considered, signposting to locations in the application documents where this has been undertaken. I then skip to the end of the health section, paragraph 123, and I simply say, in light of that, that it's clear that the scheme is positive in terms of health impacts. Then turn to issue 8, which is the effect of the proposal on climate change and carbon emissions. And again, I don't read this section, but you have there discussion of the construction and operation climate change effects. And the text also goes through the points raised by objectors, Mr. Ung particularly. And I move then straight to the conclusions on climate, which you find at paragraph 136 on page 64, where I say that overall, therefore, there will be no significant climate effects during construction or operation, and operation will have a minor beneficial effect due to a reduction in congestion and journey times resulting from the improvements to the road network. There is compliance with policy and no conflict with domestic or international commitments under the Climate Change Act 2008 or Paris Agreement, respectively. It is government policy to address emissions in a managed economy-wide manner and not for there to be a moratorium or review of all road building schemes. Then issue 9, which is whether the proposed bridge would deliver the high quality design sought by the framework and development plan policies. This is a shorter section, and conclusion is at paragraph 140 on page 66. Paragraph 140, I say that for these reasons, the design of the Didcot Science Bridge and the scheme generally will accord with design policy in the framework and the development plans. In particular, policy 16B of the Part 2 Vale Plan expects development to positively contribute to the Didcot Garden Town Master Plan principles, which encourage pioneering architecture of buildings. The high quality design of the Didcot Science Bridge positively contributes to that principle to the extent that it is applicable, given that it is particularly concerned with buildings rather than highway infrastructure. That principle also needs to be read alongside and balanced with the other principles, that's the master plan principles, including principle number 4, which seeks a step change towards active and public transport, which the active travel provision across the Didcot Science Bridge and throughout the rest of the scheme will promote. The Science Bridge will also be, quote, a recognisable landmark in accordance with the Didcot Garden Town delivery plan. Then turn to issue 10, which is biodiversity. And I do read paragraph 141, say the effect of the scheme on biodiversity was comprehensively considered in ES Chapter 9, Biodiversity, which concluded that there would be no significant residual effects resulting from construction or operation of the scheme, with the implementation of mitigation measures. The assessment further concluded that the scheme is expected to result in a slight positive effect in the medium to long term once habitats have matured as a result of the overall biodiversity net gain. The LPA's officers raised no concerns in respect of biodiversity and concluded that, subject to the conditions being included as recommended, this development would be in accordance with development plan and national policies that seek to protect and enhance biodiversity. In respect of your question, Madam, to Mr. Greep regarding species relocation last Friday, this is further information. Only 2 species might require relocation: European eel, which would be subject to fish rescue, removal and translocation, should this be required during construction, and badger. And I just highlight footnote 244 there, which provides some references in response to that question you raised with Mr. Greep on Friday. That's been provided by Professor Wade. I then skip to the end of the biodiversity section, which is paragraph 146. And I there say, for those reasons, there is no proper biodiversity reason for refusing planning permission for the scheme. Then issue 11, which is the effect of the proposal on the significance of heritage assets. And I don't read all this section. In paragraph 147 in the bold text, you see I go through the assets. There's one amendment which I'd be grateful if I could just make.
it's in paragraph 147A in the last 2 lines at the top of page 69, where the text currently says, given that the scheme will not give rise to increases in traffic volumes through Newnham Courtney, that should read, not give rise to material increases in traffic volumes through Newnham Courtney. So obviously you've got the evidence as to 2% and 6% increases. So it's not 0, but it's not material, we say. Then I talk about Clifton Hampden Conservation Area, Fulham Farmhouse, Grade 2 listed building, a scheduled monument, and then I do read paragraph 148, which is on page 70. Historic England made no objection to the application on heritage grounds, nor did the conservation officers for South or Vale. OCC, as LPA, concluded that notwithstanding the great weight and importance that's to be attached to the relevant designated heritage assets, the public benefits arising from the development weigh heavily in favour of the development and outweigh the harm to designated assets, and that the development is in accordance with national and development plan policies that seek to protect and enhance the historic environment. The applicant agrees with that assessment, taking into account the duties under Section 66 in respect of listed buildings and their settings, and Section 72 in respect of conservation areas of the Planning Listed Buildings and Conservation Areas Act 1990, and considers that the heritage and other benefits firmly outweigh the limited heritage harm arising. Insofar as the scheme does cause less than substantial harm to the significance of any heritage asset, Mr. Greep explained in his evidence that the public benefits of the scheme considerably outweigh such harm for the purposes of the framework paragraph 208. And for those reasons, there is no heritage reason for refusing planning permission for the scheme. Then issue 12, which concerns flooding, and that in particular, whether the scheme would be safe from flooding over its lifetime and the effect of on flood risk elsewhere. It's a short section which I refer to the responses by the Environment Agency and the lead local flood authority, who both were satisfied and removed their objections to the scheme. And so in paragraph 153, I simply say that there is no flooding reason for refusing planning permission for the scheme. Issue 13, penultimate issue, is the green belt. I don't read all of this section. It deals with paragraph 155C, and I go to the conclusion at paragraph 158, which is on page 74. I say, overall, in light of what I've said above, the applicant considers that openness is preserved and there is no conflict with greenbelt purposes, such that this scheme constitutes not inappropriate development in the greenbelt within the context of the framework paragraph 155C. If you, Madam, or the Secretary of State takes the contrary view, such that the scheme does constitute inappropriate development in the greenbelt outside the scope of para 155, then the applicant considers that very special circumstances clearly exist so as to justify the scheme and result in there being no conflict with greenbelt policy. These very special circumstances are discussed below under the planning balance. And then finally, issue 14 at paragraph 75, which deals with other policy matters and the overall planning balance. And I do read all of this final section. So first subheading, paragraph 160, is the position of OCC as LPA. Although many of your issues, Madam, derive from the issues originally raised by the county as LPA, it should be noted that the county as LPA no longer objects to the scheme, either as to the principle or on any technical matters. And at their meeting on 27th of September 2023, they resolved to adopt, quote, an overall neutral position. A supplementary statement of common ground between the LPA and the applicant dated 9th of January 2024 confirms that the applicant and the LPA do not have any matters of dispute between them. Next subheading, other policy matters. Viability has been raised by certain objectors. As agreed, the applicant will make closing submissions on that issue after the applicant's viability evidence has been heard in the orders part of these conjoined inquiries. Next, subheading very special circumstances. If, contrary to the applicant's primary case, it is concluded that the scheme is inappropriate development in the Greenbelt, then the applicant submits that very special circumstances clearly exist within Para 153 of the framework. The scheme meets a pressing need and gives rise to numerous and wide-ranging benefits, which individually and cumulatively attract substantial weight. Most significantly, and as I've set out under issue 1, that's need and benefits, the scheme enables planned housing and employment growth in the Science Vale to come forward, which is central to the development plan ambitions for the area in the South Oxfordshire local plan and the Part 1 and 2 Vale plans, government policy in the framework, also in particular Paras 60, 74 and 85 and 86, concerning boosting the supply of housing, planning for larger scale development supported by the necessary infrastructure, supporting economic growth and productivity, and addressing potential barriers to investment, including inadequate infrastructure and insufficient housing. There are also further benefits in respect of transport, in particular reducing congestion, improving access to homes and jobs, facilitating better public transport, and improving better infrastructure for active travel. Noise and amenity, by diverting existing and future traffic away from villages and settlements. Health, due to the noise and active travel benefits, and biodiversity net gain. In terms of harm, in addition to the harm by reason of inappropriateness, there is some harm to Greenbelt openness and some harm to the Greenbelt purpose of safeguarding the countryside from encroachment, but the harm is relatively localised and limited in scale and level, as I've set out above. There is some landscape and visual harm, but again it's relatively localised and should not be overstated. And there is some less than substantial heritage harm at the low end of the scale. This harm is clearly outweighed by the need for and benefits of the scheme, such that the very special circumstances test in Para 153 of the framework is met. Indeed, even if the level of that harm were to be assessed as materially higher than the applicant's assessment, it would still be outweighed by the need and benefits, such is their extent and the weight which they attract. Next subheading, the Secretary of State's matters. As to the Secretary of State's matters on which he particularly wishes to be informed, firstly, the scheme is entirely consistent with government policies for delivering a sufficient supply of homes in Chapter 5 of the framework, for the reasons I've set out. The scheme is entirely consistent with government policies for building a strong, competitive economy in Chapter 6 of the framework, again for the reasons I've set out. And the scheme is in accordance with the development plan overall, as I'm going to come on to now. Next subheading, Section 38.6 of the 2004 Act, accordance with the development plan. Section 38.6 requires an assessment of whether there is compliance or conflict with the development plan overall. As held in the Rochdale case, as is well known, Mr. Justice Sullivan stated that it's well established that development plan policies may, quote, pull in different directions, and the decision maker must accordingly, quote, make a judgment bearing in mind that such factors as the importance of the policies which are complied with or infringed and the extent of compliance or breach. And the judge went on to state, quote, I regard as untenable the proposition that if there is breach of any one policy in a development plan, a proposed development cannot be said to be in accordance with the plan. Given the numerous conflicting interests that development plans must seek to reconcile, the need for more housing, more employment, more leisure and recreational facilities, for improved transport facilities, the protection of listed buildings and attractive landscapes, etc., it would be difficult to find any project of any significance that was wholly in accord with every relevant policy in the development plan. In the present case, there is some conflict with the development plan policies which provide for the protection of the environment due to some adverse landscape and visual effects, in particular ENV1 of the South Plan and CP44 of the Part 1 Vale Plan. That is the extent of the conflict with the development plan, including the district local plans and the Culham neighbourhood plan, and I think I should now add the Sutton Courtenay neighbourhood plan, which I understand has just been made. Mr. Greep's written evidence comprehensively goes through the relevant policies of the development plan, and for the reasons I've already set out, only finds this limited level of conflict. Some conflict in this respect plainly does not preclude compliance with the development plan overall, given the relatively modest nature of the conflict, particularly when seen in the context of the scale of the scheme as a whole, and the fact that some adverse effects in this respect are likely to be inevitable when delivering infrastructure of this nature and size. And the scheme is also expressly supported in the development plan. Accordingly, there is compliance with the development plan overall. Indeed, the scheme is central to the development plan, which heavily depends upon it. The scheme therefore benefits from the presumption in favour in section 38.6 of the 2004 Act. The final subheading is the planning balance. There are no material considerations which come close to indicating that the application should be determined other than in accordance with the development plan. Any adverse environmental effects are heavily outweighed by the benefits. The adverse effects are few and far between, and the overall environmental picture is very positive. Overall, this is an important, significantly beneficial and urgently needed scheme, and the planning balance comes down overwhelmingly in favour of the grant of permission. And that's the case even if the Secretary of State were to find, contrary to the applicant's case, conflict with the development plan overall. Such conflict would be outweighed by the very weighty need and benefits, such that the planning balance would still mean that permission should be granted. And so in conclusion, for all those reasons, the applicant asks that planning permission be granted for the scheme. Thank you.
Just a couple of points before we adjourn. In terms of conditions, is there to be a revised schedule? I think I said I could receive it later in the inquiry as we're not formally closed. Is that in hand?
I'm sure it is, so I will double check though. Yeah.
Thank you. Could I ask all parties to submit their closing submissions to the Programme Officer in Word, please, in a Word format? Is that...
I'm pretty sure mine already is in Word.
They've all been excellent, if it is. We wouldn't have left it in Word on the website, I don't think. Right. Okay, thank you. I think the other point I want to make is that I will need to do a further site visit and visit the area further. There's an unaccompanied visit I've got a schedule for, and there's probably elements that I'd like to see again by myself. Should I meet anybody from the parish councils, I can't discuss it with you there. I'm not ignoring you, but just in order to remain impartial.
Oh.
Okay.
Fully understand that. You're more than welcome, of course, fully understand.
Okay, thank you. And then I think we're going to adjourn the inquiry because, as agreed, we won't fully close it till the end of the orders inquiry, but in practice the only bit that remains open is the viability session that we'll hear next week, and I don't anticipate anything additional to be submitted in the interim. So is there anything else that anyone needs to raise? No? Okay.
Sorry, could I just revisit, I sent an email which you referred to this morning, and is there any follow-up from us required for that? Because we're not going to be sitting as a Rule 6 party, we're not participating actively at least, but just to clarify.
In terms of the orders, there's not a Rule 6. There's a statutory objector and a non-statutory objector, which is what you are. You've said that you weren't going to participate, so we've got... it's not Mr. Harwell, was that his? I can't recall your witness's name. And there were two of your witnesses raised viability issues, weren't there? I think it was Mr. Young, maybe. So that evidence has been taken, I think, touched on with your witnesses as evidence in chief, and Mr. Humphreys is going to ask questions of his witnesses in relation to that. So although you've said you're not taking an active part, that does, you are entitled to appear there if you wish to, as the joint parish councils, but I wouldn't expect any additional documentation from you.
Well, there's no plan to submit additional documentation.
Mm-hmm.
I think the tenure with respect in the email was that to bring matters to your attention and issues that you might raise with the applicant. Yeah.
Right, I'm aware of that. It's been added to the website and the council's aware of it. Okay, and I can't say what I'll bring to your attention until I've heard their evidence.
I understand, yeah.
Okay, so so we're going to adjourn then, and I will close the inquiry, the planning inquiry, when I close the other inquiry formally then. Okay, is there anything I've forgotten? No? Okay, so those of you returning for the orders inquiry, I'll see you tomorrow at 10. Okay, thank you.
And I will take my leave.
Thank you, Mr. Woolley.